since Friday, November 3rd, 2017.
All right, if you'll call the roll, please.
Commissioner Bloom,
Here.
Commissioner Douglas,
Here.
Commissioner Franks,
Here.
Commissioner Hills,
Here.
Commissioner Horn, Commissioner McMullen,
Here.
Commissioner Taylor, Commissioner Wood,
Here.
Chairman Grease.
Here.
You have a quorum.
Okay, for the record, we have 8 out of 9 commissioners present. Excuse me. Commissioner Horn is recovering from successful knee replacement surgery. I talked to him earlier this week, and I asked him if there was anything we could do to help, and he said send over a fistful of $20 bills. So anybody that wants to participate in that, I want you to feel free to do so. So I think he's doing well, and I'm looking forward to, and I know we all are, seeing him back here next month. With that said, at this point, I'd like to ask Rick Douglas to lead us in an invocation, and then if you would stand, Rick will also lead us in the pledge to the flag.
All right, let's pray. Father, we come to you, first of all, thanking you, Lord, for allowing us the honor, the privilege to serve the citizens of the great state of Tennessee. Lord, we want to take just a moment to pray for our fellow commissioner, Johnny Horn, as he's convalescing. Lord, we just ask you to bring about quick healing in his body and get him back to us in short order. Father, we ask you, Lord, to give us wisdom and discernment, Lord, as we make judgments and decisions about the cases that are before us. Father, we just pray that you would help us, Lord, to both professionally and personally maintain a very high level of integrity. And that, Lord, that you would help us, Lord, to show grace where it's needed and to be stern where that is needed also. And we pray these things in Christ's name. Amen.
Amen. Please stand.
Flag of the United States of America, and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
All right, the agenda has been sent to each of the commissioners. Are there additions?
I have a question.
Yes, ma'am.
I noticed that the legal report begins at 12 p.m. Are we going to be here at 12 p.m. or is that just a guesstimate?
It's strictly a guesstimate.
Okay.
And for the record, the agenda also showed we have a formal hearing tomorrow. That has been postponed until February 8th, 2018. So this is a one-day meeting. Other additions or deletions or discussion items you'd like to put on, Ms. Hills?
Yes, I'd like to add one thing to maybe in your discretion, maybe in commission discussion, a Bill Toon Award.
Okay. Other topics?
Yes, in that same category, sir, I'd like to add discussion about attendance at this meeting.
Okay. Mr. Wood?
I would just a short question at some point about business cards and advertising or non-advertising.
Okay. Other commissioners?
Yes, I'd like to talk about scheduling our hearings like we were supposed to have tomorrow.
Okay. Formal hearing schedule.
Chairman, I'd like to add discussion of meeting time.
Perfect. Anything else? Is there any objection to any of those topics being added? Okay, without objection. They're added under commission discussions. Is there a motion then to approve the agenda as amended?
So move.
Second.
I have a motion by Mr. McMullen, seconded by Mr. Wood. The agenda be approved. Is there discussion? All those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Next, You also were emailed minutes of our October meeting in Chattanooga. Is there a motion?
Move to approve.
Have a motion by Ms. Franks, seconded by
Second.
Ms. Taylor. Now, Ms. Taylor, you have the floor.
Yes, under, I was quoted as saying, I don't have it with me, but something in the last line that, instead of wires were accepted to attorneys in lieu of cash. I did not say cash. It's checks.
Okay.
Okay, because attorneys don't accept cash anyway.
We'll make sure that gets corrected.
Okay.
All right, other comments about the October minutes? You've heard the motion is to approve. There'll be one slight modification offered by Ms. Taylor. Let's vote. Those in favor of approving the minutes vote aye.
Aye.
Those opposed, no. That motion passes unanimously. All right. Next up, we have a guest, Cindy Rice Grisham, married to John Grisham, right? No, maybe I'm not right. Maybe not. Okay. Cindy is with Rice Insurance. She's the face and the principal with this company, and I've asked her, and she's agreed to come before us and give us a presentation generally about those issues that are causing the most problems for licensees in Tennessee.
Thank you all. I want to tell you a little bit about who I am and who I'm with. Bryce Insurance Services Company is an agency that was formed by my family exclusively to handle real estate errors and omissions insurance programs in mandated states. The Rice family and the employees of Rice have been involved in the establishment and administration of mandated programs for many years, since 1989. We are the current group provider in 11 of the 13 states that offer a group program in mandate insurance, and we will be adding Alaska January 1. So there will be 14 mandated states. We're an insurance agency and administrator. We're located in Louisville, Kentucky. And as I said, administering group programs for mandatory E&O states is our only business. We do not write any other types of insurance programs. Another important factor that sets us apart from other insurance agencies is that we also handle the claims in-house for the group programs that we provide. Rice is staffed with 8 in-house claims specialists who are also attorneys, along with an experienced claims supervisor to oversee and adjust claims that are submitted under the Tennessee Group Program. These in-house claims specialists allow us to provide specialized knowledge in claims handling, as well as a higher level of service when an insured is faced with a claim. When an insured calls Rice with a question about coverage, they will speak directly with one of our claims specialists. These are the very same individuals who receive the claims and are involved in the initial coverage determination. When a covered claim needs defense counsel, we assign the matter to a Tennessee attorney, and we have established relationships with experienced outside counsel throughout Tennessee and other states. Unlike many agencies, we work with only one insurance carrier in the mandated programs. Our partner for the mandated states is Continental Casualty Company, one of the CNA companies. And as you may know, CNA is the #1 provider of real estate liability insurance in the United States. Rice, or our predecessor company, has been the administrator for the Tennessee Group Program since 1991, with the exception of a 2-year period, 1995 to 97. We are honored to have such a long-term relationship with the Tennessee Real Estate Commission and its licensees, and I'm here today to update you on the program and answer any questions. At the end of September 2017, we had 24,010 licensees enrolled in the Tennessee program, and I think there's about 32,000 total active licensees. We've been pleased with the number of licensees that have enrolled in our program, and it looks like numbers are a little bit up for 2017. You've been provided with a copy of the group policy claims information. Unfortunately, I made the copies in color of the 2017 second quarter instead of third quarter, but I have both copies with me, and I can tell you there's not a whole lot of change, and I will give you the correct numbers as we go through. This report includes data for each policy since 2003. It shows the number of claims reported each year and the number currently open and closed. It also shows the total incurred amount per year on this report. This report shows each group policy number, and then it lists the closed claims count, the total paid for closed claims, which is broken out into the loss payments and the legal payments. It shows the open claims count, the total incurred for open claims, which breaks out into loss payments and legal payments. And it gives the total claims count and the total incurred amounts. Since real estate E&O claims typically take years to close, for example, we still have open claims in all but one policy period since 2003, the true cost of a claim cannot be determined until the claim has actually been closed and all related expenses have been paid. As a general rule, the claims that take longer to close tend to be the claims that cost more. And one of those reasons is because you've got more years of legal fees incurring. It's still unclear if the amounts paid out in the more recent years will be more or less than the prior years. But an actuary will review the loss history and apply the loss factors for continued development in order to figure out what the premium needs to be for future years. Also, as the claims mature, the loss data becomes more reliable, so we know more about the current periods as time goes on. This is the first year of the 2-year policy period, and it's the first year of the new contract with the state for 2017. You will note from this report that we spend more on legal fees than we do on loss payments, and this is typical in our experience for this line of business. One of the most valuable features of a real estate E&O policy is the defense cost coverage, and there is no limit on the defense costs under the group policy. These amounts are all paid in addition to the limits that are stated for damages on the policy. Please note that the loss reports do not include any IBNR, which is the factor used by the actuaries to determine the incurred but not reported, or the loss development, which is the factor used to determine the ultimate loss incurred. It also does not include any administrative costs, the costs of the insurer to provide the program, including their staffing costs and expense allocations, administration, marketing, and claims adjustment costs. All of these factors are considered in the premium calculation for the program. Overall, the amounts paid out for the Tennessee program from January 1, 2003 to September 30th, 2017 for closed claims is $20,810,613. The incurred amounts, which means the paid and reserved amounts on open claims, is $3,788,075. The total incurred amount for the 3,223 open and closed claims in Tennessee since 2003 is $24,598,688 at third quarter this year. This shows the dollar impact of the insurance program for its purpose of public protection relating to Tennessee real estate transactions since 2003. It also shows the value of the program to the licensees who participate in the group. I decided to look at the claims in the past 6 years in more detail to see what our recent claims experience in Tennessee tells us. There have been 1,309 claims reported under the policies from 2011 through 2017. We hear from many insureds that believe that only a lawsuit is a claim, but that's simply not true. Some emails, letters, and faxes will meet the definition of a claim under the policy. The group policy defines a claim as a written demand for money or services. The majority of the claims that were reported during this period did involve a lawsuit. There were 735 lawsuits. That's 54% of all reported claims. 426 were not lawsuits, but they meet the definition of a claim. That's 31%. There were also 194 regulatory complaints reported. That's 14%. A regulatory complaint is not a claim under the policy, but the policy will provide up to $5,000 for defense of most regulatory complaints, up to $10,000 maximum per year. There were 25 subpoenas reported. The policy provides limited coverage for attorney's fees if a licensee is served with a subpoena for documents or testimony arising out of professional services. Then the insurance will retain an attorney to provide advice and to represent you. And this is also very valuable because if you go without an attorney and respond to a subpoena, it often can lead to a lawsuit against you. There were 3 mediation and 2 arbitration claims that were reported during this period. I also looked at the type of transaction that gives rise to claims during this period. The majority, a little over 50%, arose out of a sale. 688 were sales transactions. There were 210 property management claims, that's about 15%, and 160 contract claims, which is about 12%. The other types were less than 1% and included 99 which weren't classified in our report, 49 that involved a lease, 26 involved a listing agreement, 25 involved construction contracts, 23 involved auctions, 18 involved an offer, 15 involved leases with options to buy, 12 involved appraisals, 7 involved the sale of bank-owned property, 6 involved agency, 2 involved a broker price opinion, and 2 involved a development contract. I looked at the real estate type. 929 involved residential property. So most of the claims that we get are residential property transactions, 67% of them. 110 were coded as managed property, 86 were not classified, 74 were commercial, 74 involved vacant land, 42 were condos, 26 were apartments, 16 were farms, 12 were bank-owned properties, 12 were mobile homes, 3 were businesses, and 1 was a timeshare. Then I looked at the claims with incurred amounts over $50,000 in the past 6 years. There were 106 of them. 68 of those involved sales, 55 were residential sales, 6 were commercial, and 7 were vacant land. 12 involved contracts, 9 were residential contracts, and 3 were vacant land. 11 involved property management, 9 were residential, 1 was commercial, and 1 was apartment property management. 5 involved leasing, 3 were commercial leases, 1 was an apartment lease, and 1 was a residential lease. 5 involved auctions, 2 were residential auctions, 1 was a commercial auction, 1 was a farm auction, and 1 was vacant land. 3 of the claims were construction claims, 2 were appraisals, both of those were residential appraisals. The largest claims that we saw during this period involving actual policy limits claims during that period were as follows. There was a commercial lease where the property manager allegedly failed to collect rents from commercial tenants. There was another one where the buyer alleged the insured agent failed to disclose the tendency of the property to flood. The other one was a buyer of residential property that alleged the insured listing agent failed to disclose water damage and the presence of mold. Then I looked at the top allegations in the claims in the past 6 years. Keep in mind there may be up to 3 allegations listed in the claim report for the claim showing payment, and this is entered by the adjuster that's looking at the claim. The most common allegations are bodily injury or property damage. There were 124 claims that allege this. And this is interesting because these damages are really considered a different risk, and they're typically covered by a general liability policy, not E&O. But there is some property damage coverage included in the sublimits for lockbox claims. There's $5,000 per lockbox claim with a $10,000 annual aggregate for each insured. There's also an optional endorsement for contingent bodily injury property damage that we're offering this year for the first time. It offers $10,000 per claim and in the aggregate for damages and defense costs. These are for claims where there's no other insurance and there is actually true bodily injury or property damage. Normally, these type of damages are the claims are covered in a reservation of rights, and because these allegations are often included in claims involving other covered allegations, such as the misrepresentation of a condition or a nondisclosure of a defect, and since the insurance policy provides coverage if there's a single allegation in the claim that is covered, then the duty of the insurance company is to defend all of those claims, and they'll just reserve rights saying if it's found that it is an excluded claim, then those damages may not be covered. But many of the claims we see will allege like emotional distress because of covered allegations, or they may allege property damage that was caused by something that was not disclosed or another covered claim. So a lot of times when we're settling those claims, even though there's things that may not be covered, those will be resolved for the full claim when they're paid. The next most common allegation in claims with payment is another item that is not covered by the insurance policy, and that's fraud. And keep in mind that all these claims I'm telling you about are actually claims that had payment. So these are not disclaimed claims. These are claims that actually had payment. Again, fraud is not covered by the policy, but most claims will allege both negligence and fraud. However, since negligence is easier to prove in a lawsuit, you very rarely see a fraud allegation without an accompanying negligence claim alleged. And if both are alleged, then the policy will defend the entire claim. The third most common allegation in Tennessee during this period is that the deal fell through and no closing occurred. There were 71 claims. Next on this list is negligence, which is pretty broad, 66 claims. And that's a common allegation, and it's often used in our coding when other details of the claim aren't really clear at the beginning. Fifth is nondisclosure or misrepresentation of mold. Y'all will note that this year there is, coverage under the policy for environmental claims, so I know that that's important to the licensees. Tied for fifth is breach of duties. There were 65 claims. 6 is an alleged violation of the Consumer Protection Act. There were 62 claims that allege that. 7th is misrepresentation of rental fees collectible. 8th is conversion or misappropriation. 9th is a misrepresented condition. 10th is a misrepresented septic tank. 11th is an ethics complaint. 12th is a commission or fees dispute. And 13th is a four-way tie with 41 claims each of misrepresentation of flooding or leaks, misrepresentation of contract terms, earnest money or escrow money dispute, and breach of contract. Then the 14th is a failure to maintain the property. We're happy to be able to offer this group program with affordable coverage and valuable protection for the majority of licensees. Unfortunately, a licensee can't always do everything by the book, but still they find themselves, they do everything by the book, and they do find themselves in a transaction that's gone bad and that's turned out that they're faced with a claim. As our society gets more litigious every year, the trend continues to increase the likelihood of a claim for a real estate licensee, regardless of whether they were undertaking the proper standard of care. As you all know, a claim can be disastrous from a financial, mental, and professional standpoint, and having adequate insurance protection is invaluable. In some states, real estate licensees can't find affordable coverage, and some licensees can't even get a quote if they have a history of claims or if they're in a high-risk type of transactions that they're involved in. They may not even be able to get a quote for E&O. Since the group program in a mandated state must accept all licensees at the same fixed premium for the basic policy, the mandated program assures that E&O insurance is available and affordable to all Tennessee licensees. We're very pleased to partner with the Tennessee Real Estate Commission to provide this valuable program for its licensees, and we take our responsibility for this program very seriously. If you ever have any questions or concerns or even want to pay a compliment, please contact me and give me your thoughts. At this time, I'm ready to answer any questions that you all may have.
Thank you, Cindy. Commissioner Bloom?
I thought I was paying attention, but how many people licensees are insured in the state of Tennessee?
One moment, and I will tell you.
Started out with
4,000.
Page
24?
1.
Okay, then I don't understand how these work. What's the nature of an appraisal allegation?
Well, there's an appraisal endorsement that's available if you are a licensed real estate broker and an appraiser. You pay an additional, I think it's about $200 for the 2-year period to be covered for your appraisal activity. And so those would be covered only if you had the appraisal endorsement.
So an appraiser who is not covered by Rice would not be covered?
Right, right.
Okay. And the deal did not close. You have insurance for the deal's not closed?
Well, what they'll do is they'll allege, for example, that our agent was negligent in finding a qualified buyer, and then the deal didn't close. They should have screened them better, something like that. That's a common allegation.
I had one other question.
Mm-hmm.
What's the nature of the $5,000 for regulatory complaints?
What that is since if a real estate licensee has an action in front of this commission, it may have very important legal implications for their future employment, for their career. So in all the mandated states, it's either included in the program or it's available by endorsement to give them access to an attorney to coach them on how to address the allegations in the regulatory complaint. And it could be in front of the commission, or it could be something at a board of realtors. Any type of regulatory complaint. It could even be, something related to another, regulatory body. But because it has such an impact on them, it gives them limited legal representation. It does not cover any fines or penalties. It would only provide them with legal consultation on handling how to respond to the allegations in the regulatory complaint.
Ms. Hills.
If the broker takes the extra coverage and the agent doesn't, or vice versa,
Okay, the way that it works for the claims, each individual licensee is looked at independently. So if you've got a selling agent, the listing agent, and the broker, and there's allegations in the complaint that the listing agent, made some mistakes, the selling agent made some mistakes, the broker should have supervised better, that type of claim would trigger all three policies. And each individual has their own limits based on what they purchased. If they have the $100,000 limits and all three claims were triggered, they would each have they would have $300,000 for the total claim. But if somebody had bought the $250,000 or the $500,000, then that's added in addition to it. So all that would be available for the claim. Then in addition, we've got an excess program that firms sometimes buy. Some of the, like for example, some of the franchises will require that they have $1 million limits. So in that case, we offer a firm policy that is actually underwritten. They look at it and say how many licensees, how much, what kind of transactions are they involved in, how much are they making per year. They'll look at that and they'll give them a quote. But of course, it's a quote that's based on the fact that the first $100,000 of any claim is going to be covered. So it's typically more economic to purchase that than going out and buying a $1 million policy. Plus, if you buy the $1 million policy and you're a big firm, and you don't buy the individual plus the excess, you may find that you've got a lot less coverage, because if you have, say, 100 agents and each of them have 100,000, that's going to be more available overall than if you had just a one firm policy by itself without being in the group program. Does that make sense?
And then and I should have looked at this before this meeting. So, and I'm thinking, because I go through and I just, yep, I'll take this. So there's a sales price limit too that you can get for a sales price limit, like $250 and up.
Oh, you mean
$500 for
I'm not sure I'm following.
Yeah, I'm thinking that, and so if they don't get something that something that covers a sales price.
I'm not sure. You mean if there's a claim alleging that they didn't they didn't give the right opinion as to what the sales price should go for, that they misrepresented? Is that what you're talking about?
Or the sales price of a house, covered of a house.
Are you thinking like some agents sell $250,000
Right, or
houses and
less.
some sell $1
And-
million houses?
Yes.
Is there any
there an-
difference in the cost for those?
Isn't
No,
there
but you may be thinking we have increased limits available
Yes, that's
for
what I'm talking
individual
about.
licensees, and
Yes.
for that,
So if I take the higher limit as the broker, yet the agent takes the lower, or doesn't take an increased limit, does that add the same way that you just
if
described?
both policies were triggered, meaning
Okay.
if there are allegations that the broker did something, a lot of times they'll allege, the broker should have, supervised them better and not let this happen.
Okay.
So in that situation, it would. And
Okay.
I think what you're talking about is the increased limits endorsements that's available for
Yes.
the individual licensee. And if they buy $250,000 per claim with a $750 aggregate, it's an additional $134. And then if they buy the increased for $500 per claim with $1 million aggregate, that's an additional $249. Now that's for a 2-year period, so it's really affordable to
Oh,
get
it
those.
is.
Yeah.
It is. Okay.
Yeah.
But that could then add between the broker
Right, so
and
that
the
makes
agent, too.
more potential limits available in the event of a claim.
Okay.
Because the more policies that are triggered, then they add up on each other.
Thank you.
Most of the claims we see do not get anywhere near the policy limits. I mean, it's kind of interesting. One of the things that we notice a lot with this type of program is, a real estate licensee does not have a duty to inspect, at least in most states. There's one state that there's some case law that says that they do. One where we write. But you don't have a duty to inspect. What you have a duty to do is to disclose anything that you have actual knowledge of. So a lot of times people will say, but I didn't do anything wrong, this is a frivolous case. Well, what you have to realize is the other side doesn't know what's in your file. You might have that termite report, or you might have something saying the roof needs to be replaced. So until they go through discovery and find out what you actually knew, it's not really a frivolous claim. You just didn't do anything wrong. And that's what I have to make clear to people. A lot of people are like, this is crazy. I shouldn't have to have insurance. I'm very careful. The thing is, you get named in claims all the time. Whenever a transaction goes bad, they name everybody. That's the first thing that you learn in law school. Shoot the bullets everywhere. You'll maybe hit somebody that's going to pay you something. So what they do is they'll name everybody involved in the transaction, including the real estate licensee that was involved. And then that's our job to come in and determine, did they do something wrong? If they did, we try to get an early settlement. If they didn't do anything wrong, we try to defend them. And, the policy does have, provisions that if the licensee does not want to settle, they don't have to. It just, at some point, oftentimes, even if you know you didn't do anything wrong, it's better just to get it behind you. And so a lot of times people are like, that's fine, just settle it, get rid of it. But that's just the way it kind of works as we go through.
Ms. Franks?
So mediation, that's not required then usually on policies that mediation take place?
No, it's not required in the policies, but it's required by a lot of the contracts that we see, like between the parties. So sometimes they'll require mediation, and if we get a claim that asks for mediation, then obviously the defense of it would be to assist in the mediation.
And this may be a question for our attorney. Are all timeshare, different positions in timeshare, are all of those people required to have E&O insurance?
I believe they are. I'd have to double check it, but
So it's all licensed?
Sue can answer that.
okay. I was gonna
Okay.
say, we have a timeshare expert in the room.
Okay. And I heard you say that you settle ethics complaints too, so that would be with the local associations where you handle those ethics complaints?
Well, sometimes it might even be, it would normally be ethics complaint at the association, so they would provide a defense of that claim. Like again, if it's a regulatory complaint, there's no coverage for the penalties or any kind of loss payment for that. It would just be the defense in those situations.
Bobby?
One of the many things I learned being on the commission was that Rice assists in filing a response to a complaint from us. But did I hear, let's say that complaint leads to a hearing, do you assist in that at all, or once it reaches a hearing?
Well, we assist until they've run out of money available. I think it's $2,500 per complaint that they get. So
Okay.
it's basically kind of enough to go in and advise them, make sure that they're, know what the legal implications of any kind of, statements that they make might be, so that they know going in. And the attorneys will come with them up to the point where, it's paid for. Then if they want to continue paying them, they can pay for it themselves after that point.
Right.
Mr. McMullen?
Good morning. I know that you've talked about several different endorsements that are available. I wanted to ask about just kind of the base policy premium, I guess, that you charge.
Mm-hmm.
Is that the same for every licensee
It's the
across the
same
state?
for every licensee.
Okay.
Everybody pays the fixed amount. It's $221 for a 2-year policy period. It is the least expensive of all the states. Like in New Mexico, it's I think $320 for 1 year. And in Alaska, it's going to be a whole lot more than that. But we're still in the process of getting everything finalized. But it's a lot more.
Okay.
And the way that we base the premium, and for example, in Tennessee, we have many years of loss history. We can look and see how much do we normally pay out for claims. And then they look at it and they figure out what is the acceptable level, and then how many people do we expect to enroll, and then because we've done it for so long, we expect high participation. So if you've got this many people paying this amount and here's your amount you expect to pay, that's how you figure out what you need for the premium. And I mean, this is a really, really good deal for the licensees in Tennessee, and I'm sure if they do business, with maybe they have another, branch that's in another state, they probably are wishing that they could relocate to Tennessee to get the better premiums. But it really is a very affordable, and I think that it's a very comprehensive policy too. It covers a whole lot of things that a lot of the other ones, don't cover even for more money in other states. So,
thank you. As you've seen, this group has several questions about the coverage for those regulatory complaints.
Oh, yeah.
That's kind of interesting to us. I did want to ask a follow-up question about that. If a complaint is filed against a licensee, I know one time I think you said $5,000 or $2,500. There's some dollar amount of legal coverage that will be provided to assist with the defense of that. Is that if that licensee has that complaint filed against them, is the attorney assigned by Rice, or is it an attorney of that licensee's own choosing?
it's typically recommended.
Okay.
Attorney. Most of the time, licensees don't have a lot of relationships with attorneys other than closing attorneys. If you've ever been, involved in any kind of litigation or any kind of hearing, you know that closing attorneys, that's not what they do. So typically, like somebody might call and say, I have a cousin that's a lawyer. And you might say, well, let's talk about if they're experienced and they meet the criteria, we may consider hiring them. But most of the time after we've talked to them and told them about how long we've been doing this and that we have, a particular attorney in their town that has handled, hundreds of claims for us and we've gotten really good results, they generally say, that's who I want, that's who I want.
Thank you.
Mr. Douglas.
Yes. With the basic policy, is there any coverage for property management issues?
I think that it is. Let me double check because it's different in every state. It might be property management endorsement. Let me check. It is a property management endorsement. I'm sorry. It's $100 for a 2-year period to
Okay.
add to that.
So of the 24,000 insured, what percentage of those carry a property management endorsement?
I don't know that,
percentage?
but I could find out and let you know.
Would you say it's very small?
I would say it's a small amount, yeah.
Okay. The reason I'm asking, and I don't know if I'm interpreting this correctly or not, but when we look at the real estate transactions on that page, property management was 15%. I would doubt that 15% of the insured are carrying a property management endorsement, right? So that means that's really a pretty large amount.
That amount is from covered claims, so it's not counting the claims
Okay.
that I think that the ones that list the most common allegations we only looked at the covered claims because a lot of times we'll get claims occasionally that are not even E&O claims. It'll be like I wrecked my car on my way to an appointment. That's not an E&O claim. You get just random crazy claims sometimes. We also sometimes get claims directly from the person who's been harmed, and that's not the way the policy works. It has to be reported by the licensee that's insured with us. So we'll always encourage the licensee, hey, this person's calling, you might want to report this claim. But the way that for property managers, I would say, most people that are doing property management would want to purchase the endorsement. I would say they're either on our program purchasing the endorsement or they're buying from somebody else that specifically covers it because there are property management claims can be very expensive, particularly because typically they don't allege you made one mistake. They'll say for years they've been failing to collect rents or for years they've been, mismanaging the property and not, maintaining and doing the things they're supposed to be doing. We've been paying them all these monies for years. That's why property management claims are more expensive because it's not a single transaction. It's one after another, and then sometimes you get a situation where maybe the whole building is bringing a complaint, or every tenant or the owner of the property saying you didn't collect for the whole shopping center for years, and then it gets really expensive because you got to go through and pull documents for years and years and years and years, and just defending it is super expensive. That's why it's really important for people that are doing property management type things to be
One follow-up question with that. I know you said that once a claim has been made, that you guys would recommend an attorney who specializes in that particular area. And I'm thinking about property management now. So if an agent wanted to move into doing property management, rather than wait until a claim is made to get a recommended attorney, can they pick up the phone and call you guys and proactively find an attorney who handles property management in their area and maybe have that attorney
We
on
could
retainer?
tell you attorneys that we've used for claims. It might be harder to specifically find someone that specializes in property management from our claims data, but we could certainly look, see if we had a property management claim that attorney had handled, and we could say they've handled it for us.
Thank you.
Marcia.
I have one more question, and I don't know if it's for Cindy or not, but do we have the authority, if somebody's coming in with property management cases, do we have any authority to require any endorsements on their E&O?
I don't think we have the authority to tell them they should. I can tell you that in the outreaches this year, I preached that it was not covered by the basic policy and that they should reach out to their insurance provider and pick up that coverage if they're doing that type of business.
Because for $100, I mean,
Yeah.
that's all.
Diane.
And I just made some notes to myself. I always look at the endorsements, but it reminds me I need to be sure all my agents look at the endorsements. But the can the endorsements be added midstream during a?
They can. There's a form that is, it requires you to fill out that you don't have a claim.
Right.
And then we have to review it and get the blessing from the the carrier. Most of them we can do ourselves. But basically what they do is they say, are you aware of a claim? Why are you asking for the endorsement? And if they say, because I had a transaction that went terrible last week and everyone said, you better buy more insurance, then that's a reason to say, we're sorry, we can't do that. But, or if we actually have people that will come in and buy a higher limits and send in the claim with it. And then they don't understand why we can't authorize that. But so you can, there's a form to fill out, and it's real easy to fill out, and most of the time it's not a problem at all getting those approved. There are situations where it's like, whoa, something's not right here, we're not going to do this. So they don't have to do it, but I see very few that we've ever had to decline.
Because situations change, people go into property management, or they were new and didn't think about the
A
endorsements.
lot of times people have a
and things
customer
like
that requires them to carry a higher limit than what they're currently
Right.
carrying, and so they'll, they're doing a different type of work for a different customer, and they'll say, my client is requiring me to carry higher limits because I'm entering into a new business relationship with them.
So, Cindy, if I understand this right, let's say I'm the principal broker. I'm an independent contractor. I buy my own errors and omissions insurance. I have an agent who also buys it, but the firm does not. It's optional for the firm.
Right.
Okay, a lawsuit comes in. It names the agent, the principal broker, and the firm.
Okay, so the agent and the principal broker's policies are both going to respond. In the definition of an insured with this policy, it covers the individual licensee who's purchased coverage, and if there's coverage for that individual, it covers any firm that they're affiliated with for its vicarious liability for their acts. So if you have been at 5 different firms and you have 5 different lawsuits in one policy period, it's going to respond to each one of those, and it's going to respond to protect the firm that you were with that was involved in that transaction. So that way it protects the firm. But one of the things we do offer is that the firm itself can purchase to have additional coverage available because that policy may be triggered.
So if I'm the principal broker and this lawsuit comes in and I find out for the first time what this guy's alleged to have done, and I release his license, he's still covered.
Mm-hmm.
I'm still covered. Mm-hmm. We each get our own attorney about this time because we have an adversarial relationship, right? Are we? The firm is still hanging out there, but vicariously it's covered. Is that right?
The firm is going to be covered for any vicarious liability, which is just liability that's attributable to the firm for the acts of those licensees that were involved in the transaction. So the policy defines that it's going to cover the licensee, and for a covered claim, it's also going to provide coverage for any real estate firm that that licensee was affiliated with for its vicarious liability. So if the firm did something like in their handbook, they said, you know, go out and do X, Y, Z, and that's the allegation that the firm itself did something, not, you know, that they were following, you know, the handout that the firm gave them when they were hired, that arguably would not be covered, but it would probably be covered under the broker's policy because the broker probably was responsible for putting that out. So, you know, it's basically it's there to protect the firm for anything that any of the individuals have done.
So our firm, we buy it for the firm, and I think it's a good investment. It's a cheap investment. But if we didn't, we're still covered.
Right. It's designed to work that way.
All we do is get an increased liability or pool of coverage, basically, when we buy it.
If that one's triggered too, and they look at it's all based on the allegations. That's the way with an insurance defense policy, that you look at the allegations of the complaint, and does this trigger the policy? And I mean, like as you've seen, we pay out a lot, so obviously they've triggered a lot.
So at least you could say we did everything we could.
All right, Diane.
All right. And so when the agent retires, John's agent retires, that agent has the option to keep the insurance.
Yes, they can buy an extended reporting period, which will make the policy apply to claims that have happened after their policy has expired. So if you retire this year, your current policy is going to continue until it expires January 1, 2019. And then at that point, they have 90 days to purchase up to a 3-year tail. And the 3-year tail is typically, it's like 200% of, it's normally, give me a second.
But then after the 3 years, can they renew too? Or is it just the 3 year?
The policy does not give them an automatic right. That's because the way that insurance laws typically work, they require you to give a certain amount. But I have had situations where a person has said, I want to buy more than 3 years, and if the carrier approves it, we can issue an additional 3-year on top of that.
Other questions, comments? Hey, Cindy, we appreciate it. For the record, for people who are not sure, this commission does not select who the state's E&O coverage carrier is. That's done up on the Hill. Is there a procurement department or a purchasing department? But it goes through a bid process that has nothing to do with this commission. So what we ask you for today and what you agreed to do is come and give us an update on what's going on in the errors and omissions insurance. I think it's very helpful, very educational, and I certainly hope a lot of people watch this portion of this video. It's very good, Cindy. Thanks very much for being here.
Thank you. And I'm going to go out and try to put some money in my meter.
Take care. All right. We've got a couple of informal appearances. Is Mr. Stracker here? Okay. Sue, is that yours? All right, Caitlin, would you like to read into the record what we have here?
The applicant is Trad Stacker. Principal broker is Sue AC. Mr. Stacker has taken and passed the Tennessee real estate exam for a timeshare salesperson. His principal broker is an active licensed broker. She is responsible for supervising 100 plus affiliate broker and timeshare licensees. There have been no disciplinary sanctions. The firm is Wyndham Vacation Resorts, Inc., Smoky Mountains. And the summary of the disciplinary sanction is a felony attempted aggravated assault. Mr. Stacker accepted a plea of nolo contendere to felony attempted aggravated assault and has completed his sentencing and probation. Mr. Stacker's statement can be found on the iPads.
Thank you, Caitlin. You want to swear the applicant?
Yes. Will you both raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. And make sure when you're speaking to speak into the microphone and the light will turn red if not.
All right, thanks both of you for showing up this morning. Mr. Is it Stracker? Am I saying that right?
Stacker, sir.
Stacker. I've got a typo. No, I don't. I can't read. Sorry. Mr. Stacker, would you like to give us your version of what happened, when it happened, and what you've been doing since it happened?
Sir, and I appreciate the opportunity to come before the commission, and thank you for your time.
You have to get a little closer to that microphone. if
Yes,
you don't
sir.
mind. Thanks.
In the early summer, June of 2010, I had an altercation with my former wife. I had been working quite a bit. I had married my college sweetheart, and shortly after leaving Middle Tennessee State University, found myself in a sales job where I was away from home quite a bit. During that time, my wife wound up going out with friends, partying, and became addicted to a number of different substances. And I woke up one morning to find her kind of pacing beside me, already speaking about shouting more so, how I didn't care about her, and I was a piece of you-know-what, and kind of woke up in the midst of that. While she was going on at great lengths about how I didn't care to be around her or spend time with her and provide for her, I said something that I shouldn't have said. I took something from her past that I knew would hurt her immensely and screamed it at her. Immediately, I could tell that it really broke her heart, put her in rage, and she jumped on top of me on the bed, trying to cover my mouth while I continued to bring up things from her past. She proceeded to start putting her hand in my mouth and down my throat, and when it stopped at her thumb, during that time, I'm moving back and forth. I struck her multiple times in her side, and I bit down as hard as I could on her hand. Upon doing so, we rolled off the bed. I took my ring off, and I threw it at her, and I said that she was not who I thought that she was, and that we were over. She cried and followed me out into the living room on her hands and knees, begging me not to do this. I proceeded to yell obscenities and scream F you at the top of my lungs, and she stood up and wiped the tears out of her eyes and said no F you and left. I proceeded to go in, clean myself up, took a shower, and came back outside into my bedroom with a number of sheriff's deputies. She had alleged multiple versions. If you look at I'm not sure if you have access to my arrest report, but I initially was arrested for first-degree attempted homicide. She initially said that I threatened her with a gun. Later on, when that was found to be false, she had changed her story multiple times, and later on it was that it was a pillow. The physical marks that were left on my wife was the bite mark on her hand and where I struck her on her side. The better part of a year, she went off to California and had a number of different relationships while I tried to work through the legal ramifications of what I got myself into. I was very fortunate that the former district attorney for Williamson County, Mark Puryear, took on my case at a reduced rate and helped me through a very tough situation. The district attorney came back, and because my wife was uncooperative and because her story had changed so many times, they reduced and offered a plea agreement for attempted aggravated assault. While of course, the initial charges I had did not agree with in the slightest, it was explained to me that if I attempted to go through a trial, that there would be no way, just because of how it was stacked, something would come away. I very much admit to what I did to contribute to a very toxic situation. You know, I acted with malice, and I was cruel in those moments. From that time, I was fortunate to work with an indirect Verizon wireless carrier and become a sales manager over multiple locations. From a professional standpoint, I was top manager in my organization. Once going through the outcome of my plea agreement was a 5-year suspended sentence. At the time, when I was initially arrested, I had moved up to Pennsylvania, where my father lived. Once the sentence came out, I had my probation moved. It was supervised 5 years to the state of Pennsylvania. Upon doing so, I was offered an opportunity to come on board as a sales manager and district manager for Target Mobile program, overseeing mobility and digital service sales, where I worked for 4 years. I was provided the opportunity to move back to Tennessee and did so. My mother, at the time, was diagnosed with stage 4 breast, bone, and lung cancer, and during that time it provided me the opportunity to be here and around her. She passed away last year, and with the demands of being a district manager and overseeing Nashville and Knoxville, I was very busy, and my mother made it a big point to spend time with the people that I love and care about the most. I was provided the opportunity, an insight into the opportunity with Wyndham, timeshare, and very much fell in love with the organization, their core values, and the future that it could hold. Come on board, and I understand that because of my background with Just Cause, there is reason to worry and to have concern. I try very much not to minimize or deny what happened. I am accountable for my actions. I try not to let one day of poor judgment define who I am. I am more than happy to speak to, not happy, but I'm willing to speak to any questions or concerns you may have concerning my character or my judgment. I've also brought with me, I have 5 character references from different colleagues, as well as I've been remarried about 2 years ago now. My wife, Stephanie Stacker, is sitting right out there, as well as a citizen's commendation for heroism from 2000 to speak to who I was before and how I've conducted myself after this event.
All right, Commissioners, questions for Mr. Stacker? Mr. McMullen.
Good morning. Thank you for being here. Following up on this unfortunate incident that you described, how do you keep yourself from being in a kind of situation where you might have that kind of response again, or if you are put in a situation that's an extremely stressful type of situation like that, how do you avoid having that kind of response in the future?
Sir, and I appreciate your question. I was very stubbornly in love with that woman at the time, and there were multiple points where friends and family had pointed out that it was perhaps not the best fit. Upon resolving the matter, I went through a year of weekly counseling as far as how to handle particularly stressful situations, as well as with if you're in a confrontational environment, how best to walk away to minimize the situation or remove yourself from that setting. So I successfully completed that for a year, and outside of this incident, I have relatively led a life without any sort of conflict or incident.
I'm going to go to the broker, but if you have a comment or a question.
I'm very impressed with Trad, and I want to. I'd like to wish him and his wife the best.
Thank you, Gary. Before we accept a motion, let's hear from the broker. Sue, if you'll tell us, by the way, this is a legendary figure in the timeshare business, and she's been here more than once. And what she has,
I used to have a reserved parking space, and I want to know what happened.
We want to know where.
Yeah, we had one of those too.
Yeah,
Don't get us started.
yeah. All right, Sue. For the record, tell us why you're interested in taking this gentleman on as the person you're responsible for.
I've talked to Trad several times.
Would you get that
Several
microphone
times.
a little closer to you?
Yeah.
Or get closer to it.
I've talked to Trad several times, and I've been impressed with him every time that I've talked to him. And he's very active in sales. I think he would be a big asset for Wyndham. And one of his best friends is working there that recommended him, and we sent in several references, and he's got more. He said he had more that he could bring, and I told him that we'd already sent everything in. But like Gary said, I'm very impressed with him, and I think he would be a big asset for Wyndham.
So what do you see him doing there?
Well, he's going to be in sales. I mean, he's going to be in sales.
Oh, I continue to try to understand your business. So the person out there on the street that gets him to come in, what's that person called?
Body snatchers. They're called CMPs.
No, there's what we have acquisition
Oh,
agent.
yes, and CMPs, we call them at our office.
Oh, this gentleman is not going to be an acquisition agent.
No, he's going to be in sales. He's going to be on our sales floor in-house, which means that he deals with owners. They'll be coming down to our office and going through a presentation, and then they break off with the salespeople. and that's what he'll be doing. So he'll be on the sales floor with other agents.
But it's safe to say you're in favor of Mr. Stacker getting a license.
It is. They had some other people that they wanted me to come bring to y'all, and I told them I wouldn't do it. I was impressed with him.
Mr. Bloom, I believe, made a motion to approve Mr. Stacker's request.
Second.
I meant to do that.
I still have questions.
Okay, and I've got a second by Ms. Hills that your license be approved. Now, comments and questions. Ms. Franks.
I'm wondering if you were indicted, right? And do you still have a restraining order of any type on your ex-wife? No, I don't. Okay. Were there children involved? No, ma'am. Okay. You had a good man in Mark Puryear, so I'm from Williamson County also. So that's all I had.
All right, other comments or questions? Mr. Douglas.
I just had a comment. You know, we've had others come before the commission in my short time having been here, and one of the things I noticed many times is that even though they have served their sentence and their probation and have admitted guilt, they still in some way pass blame to someone else. And I was impressed that you did not do that. You shared the entire narrative with us. I was very impressed that you didn't hold back any of your fault. And also that you are very articulate, and I think you're going to make a great addition to this organization.
Okay, I sense we're ready to vote. Those in favor of the motion to approve, vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Good luck, sir.
Thank you all very much.
We appreciate your time.
Do you have a second person?
We did, but they came down and told me that he had already been approved.
Okay, so
What?
The second on the agenda is the one that you referenced that you are not representing any longer.
Wasserman?
Yes.
No, there was another one. Gowan, and they told me that he had already been approved.
He didn't need to
Wasserman.
appear.
Okay,
The other gentleman that was here.
Yeah.
so you don't have any other business in front of us.
But I thought she had Wasserman.
No,
No.
So what status?
He called and talked to Trek and told him that he was going to work at Wyndham, but I didn't want to bring him in front of you.
Gotcha.
so I always like to ask one question, if you don't mind answering. I'm hearing a lot of advertisements right now for companies saying they specialize in getting people out of their timeshares. Is that a fraud, or is it legitimate?
Well, there are a lot of frauds out there. There are a lot of frauds out there. We've had, in fact, Wyndham has had several companies locked up. Officers locked up. If it's a legitimate company, it's good. But Wyndham doesn't do resales, and there are companies, and there's a market for it. But some of them, we've had people lose tens of thousands of dollars, each individual. So
If there are scams, how do they work? Does the owner have to put some money up to get them to?
yeah, they tell them that if they purchase something else, that they can get rid of this, and this is going to save them money. Or if they pay them a certain amount, they'll take their property, and the people still owe money on it, and they don't ever pay it off. So the people are out like $10,000, $15,000, $20,000, and then they still owe for their timeshare. We've had a lot of people. I've closed a lot of people that has happened to. So we always warn them. We send out notices. We put information in our quarterlies that we send out to all of our owners, warning them about people and checking on them to make sure that they're legit.
Who does the resales?
Century 21 used to do them. I think they have a separate timeshare market, some of the Century 21s, and I'm sure that there are other legitimate real estate companies that do it. Also, individuals can actually sell it themselves. on eBay.
If a company says they can get you out of your current timeshare, do they need a real estate license to do that?
They should.
But do they?
I don't know.
I mean, do they need one? I know they should, but
Well, if they're selling real estate, if they're selling more than 5, I guess they're required by law to have one.
I just, your industry fascinates me because I can't figure it out, and I can't figure out that piece of it either. I'm not exactly sure if it's somebody out of state doing it, if it's scam, what it is, but
And there are a lot of scam people out there, and we've had a lot of people leave our organization, and they know how our organization works, and they use that to sell people, to resell people, and take advantage of them. So, I guess
Need you
there
to
are
help
bad
us
people
police
in
that.
all. Ma'am?
We need you to help us police
Oh,
that.
I do.
Okay.
I try.
all right, any other questions for Sue? If not, best of luck. Thanks for coming.
Thank you.
Have a safe trip back, and we're going to take a 10-minute break.
Thank you very much,
Thank
and I
you.
hope y'all all get a parking space.
Speaking of which, there were none in that parking.
Okay, in the meantime, let's move over to the Education Director's report.
Mr. Chairman, members of
We
the
have
commission.
one more.
Thomas Cunningham.
Oh, Thomas Cunningham. Do I have him on my list? I'm sorry. Thomas Cunningham. My apologies, sir. Would you like, is there anything to say about this?
I can give you a little bit of the details, and then I'll let you fill in any gaps. Mr. Cunningham's license expired on 8/22/2016. The last payment we received was 8/13/2014. So he has been expired for over slightly a year when he contacted us. He contacted us on 9/11/2017. I'm sorry. So it was a little over the 1-year mark for eligibility to be reinstated.
All right, Mr. Cunningham, I want to get legal's take on this first, and then we'll get your statement, okay? Ms. Matthews, what's your take on this?
Under the rules, since he's been expired for over a year when he contacted us, the commission does not have the authority to reinstate him without asking that he retest and reapply.
That's legal's position, and that's
Yes.
that's the summary of the rule.
Yes, Rule 1260-01-.21. I can give you the page number if you'd
Oh,
like it.
that's good. All right, Mr. Cunningham, if you'd like to tell us, you've heard the report of legal, which kind of puts us in a box. We don't have a lot of opportunity here to help you, I don't think, but if you'd like to try to make a case.
I wish I'd have known that before I came here. If it's a law, rule, I understand. I don't know what happened, why it did not get renewed. I have not had any correspondence from the Tennessee Real Estate Commission in I don't know how long, through emails or mail, physical mail. And when I did call, I was going through my wallet, emptying receipts and old business cards, and I ran across my contractor's license. I'm basically a real estate developer and contractor. I don't do any brokerage work. I don't have any agents. I don't represent buyers or sellers. I kind of maintained my broker's license all these years. When I wanted to buy a piece of property that was listed, participating in the commission. But anyway, I was going through and I pulled out my contractor's license and I thought, well, where's my realtor's license, little card? Couldn't find it, and I thought, that's strange. I hadn't heard anything from anybody. I got online, saw where it expired, and so I called immediately, and the lady told me that it was past the 1-year mark by a week or so, a couple of days, whatever it was, and so she said that I could come and appeal to the board, and I guess what I'm asking for is my license renewed. Like I say, I use it just when I'm buying a piece of property. I don't, at this point in the game, I don't really want to retest. I don't want to have to go through the educational part of it and all that. And so any consideration that I can get from the board on that end, I'd appreciate it. I'm not in the brokerage business. Like I say, I'm not going to solicit any listings or represent any sellers, buyers, either one.
It's not an uncommon request. I mean, people on a fairly consistent basis fail to renew their license. And consistently, we've been advised by legal that we don't have any latitude in it if it's over a year.
That's correct. And actually, I would, just so you're aware for the future, the notice, there's no requirement that Trek actually send notice of the license. It was a courtesy, and I believe Caitlin checked the address, and there was notice that was sent out to your address that was on file. So
That's what she told me. But honestly, I mean, I understand. I'm not going to explain. The mail that comes to my house is legal mail only. Everything else goes to my P.O. box. LLCs I'm involved with comes to a physical address. The physical address that my license is located at is my 1906 Madison Street, where I do live. My wife or I get the mail every day. My wife throws nothing away, so I know that it was not, thrown away. I go through my mail. Nevertheless, if that's the way, if it's legally that I can't, there's no leeway here, I understand. I'll just, let it go with that.
I don't think we can help.
Yeah.
I wish you had understood that.
I was told I could come and appeal it to you guys, and so I mean, I wish I'd have known that I was in a box. I wouldn't drive here this morning, but I do appreciate y'all taking the time here to listen for whatever it was worth, and
But we understand your predicament. We're kind of
That's
handcuffed.
Okay. That's okay.
Sorry.
All right. Thank you.
Thank you, Mr. Cunningham. All right, let's go to the Education Director's report. Ross.
Mr. Chairman, members of the Commission, good morning. I want to present to you the education agenda this morning for November the 8th. I've reviewed all the providers, the instructors, and the courses for this month, N1 through N23. I submit them to the Commission for your approval.
All right. Is there a motion or?
I'll make a motion to approve.
All right. Motion by Mr. Wood, seconded by Ms. Taylor, that courses N1 through N23 be approved per the recommendation of our Education Director. Is there discussion?
I just have one question.
Yes, ma'am.
What does CNE stand for?
CNE.
Could it be Certified Negotiation Expert?
That's correct.
Okay, thank you. Maybe that's why I don't know.
Other questions? All right, let's vote on the motion. Those in favor vote aye.
Aye.
Those opposed, no. The motion passes unanimously.
Thank you, Mr. Chairman, members of the Commission.
What about instructors? Do we have any this week?
You had one new instructor, Robin Quick.
Your recommendation, we approve her.
I would recommend you approve her. Yes, sir.
Move to approve.
Second.
I have a motion by Ms. Frank, second by Mr. Wood, that Ms. Quick be approved per Education Director's recommendation. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, on to, I'm sorry, Ms. Hills.
Just one thing. I did take an education class, and the instructor was Commissioner McMullen, and he did a wonderful job. I just wanted to say
You act surprised.
No, I was not surprised. He did a wonderful job. So I just wanted to add that.
And one of the things that I liked about it, I wasn't able to take the class. I would have loved to have taken the class, but it filled up at TAR. But I was able to watch it on YouTube. And I loved that for people like me, I am grandfathered, who I don't necessarily need the hours, but I still wanted the information. And so it is on YouTube if anybody would like to look at it.
Now I was able to take it. He was in Nashville, and I was able to take it from Kingsport. So we went to our
That was great.
association, signed up, and did it through there.
So how do we search in YouTube to find this video? What's the keyword? McMullen?
TAR, no, it's TR. TR now. And Austin McMullen, or you could, what was the name of the class? can't remember.
Oh, I
What is
haven't.
Trek and why do I care or something?
Yeah.
Yeah. It was very good.
But you can find it.
It's very good. I just wanted to.
I just took a
Thank you.
chance to see if they had YouTubed it, and they had. I'm like, oh my gosh, it's great. Listened while I was cooking supper.
Oh, man. Invite me over next time.
All right, Caitlin, let's get,
Well, since Caitlin's not here, I don't know where she ran off to.
you have a legal report?
No, I'm not doing the legal report, but I don't want to embarrass her, but this is Lillian Watson. She's our new paralegal for Trek.
Hey, Lillian.
When Caitlin took this position, Jenica, who used to be the paralegal for Trek a few years ago, took Caitlin's old position. Rihanna took Jenica's old position as the office manager for legal, and so we pulled Lillian on board. So Lillian is observing you all today, and
Bless
she
her
will be she will be working very closely with Robin and Erica. So
What's your last name, Lillian? Watson.
Welcome.
Yes, glad you're here.
All right, Caitlin, I'm in the mood to go to your report.
Okay, great. Sorry about that. So, as far as the numbers go, everything is pretty consistent with previous months. There are a couple of topics that I wanted to update everyone on. Sarah and I had a pretty successful meeting with ARDA, which for me was reassuring because they are the timeshare organization. So as we're sort of navigating through timeshares, it was nice to meet with that organization. I also wanted to update everyone that we are continuing to work through getting all transactions online. And as of the last couple weeks, reinstatements are now available online. So that should significantly expedite it for somebody that realizes that they let their license expire and they have the option now to pay online. So they don't have to have us send them something, then mail it in. So I know when people are expired, they want to get back to active as soon as possible. So that should expedite that. Ross and I are also working on getting all education courses, instructors, providers online. So our goal is January 2018. It might be a stretch, but we're currently working on that and preparing for the next renewal cycle, which will be September 2018.
Renewal cycle of what?
So all courses renew at the same time. So it opens up September 2018 and goes until December 31st, 2018. And then lastly, we are looking to switch up some of the outreach that we do next year in order to make the most of sort of our time as well as resources. We want to do 3 outreaches hosted by Trek in each Grand Division. And so invite all licensees in West Tennessee, invite all licensees in Middle Tennessee, and in East Tennessee. And that way we can kind of do it in correlation with, when we're going to be in West Tennessee for the meeting, and not necessarily do it with just one association, but have it be an open, free outreach for all licensees in that area.
So where would you probably have those meetings?
So that's why I mentioned this now, is because we want to start working on it now. But we would, through the education fund, Trek would sponsor the event. And so we would look to have it at maybe a local hotel conference room, or, an area that would be big enough for, as many licensees that want to attend.
So our recovery fund is very healthy right now, and so this is a way for us to use that fund so it doesn't get swept at some point. Essentially following all the guidelines under statutes and rules, we just have to make it available to all licensees. We can't limit it to if you're an association member or anything like that, so we would try to pick an area. I know with East Tennessee and West Tennessee, sometimes it's harder to pick a location that's good for everybody, but we would ask for suggestions if you have any.
So I'd like to get Commission's thoughts on how far an agent would travel to get an update from Trek.
And they're still going to get
a
the,
free update.
they're
Well,
going
we don't,
to,
they're free now, right?
Yes.
We're not charged now.
but they're getting hours for it.
Yes.
So, but would somebody from Memphis go to Jackson for this?
Yes.
I would look and see where the most licensees are. If there's more towards Memphis, I would put it more towards Memphis.
Microphone, please.
Microphone.
If you're in Jackson, there are a lot more people that would have to travel further from Jackson, because Jackson itself is a big town, but it supports a lot of associations around it. Memphis certainly is bigger in itself, so yes, there'd be more people closer to Memphis.
I think we would probably want to see how it goes next year as well. And in the future, it could potentially be treated like something like we do with the commission meeting, where we are alternating the location to accommodate from year to year.
I mean, also at this point, if we decided that we needed to do 2 in that area because it's such a large area, I think that we could probably.
I think the big thing is we would like to tie it with, us making sure that we can get as many people as possible, and then also having it make sense with us when we're already traveling to that area.
I did lots of driving this year.
You did? Oh my gosh. I think it's a great idea.
And don't get me wrong, the outreaches were great, and in places where they didn't think they were going to have as many people. I mean, Kingsport, they had to find chairs to load people into the room. So, but I mean, the Memphis one was great because we were already over in Memphis for the Collierville presentation, so that kind of worked out. But
And so it would take the place of, I call it the road show. I mean, so it would take the place of that, you think?
yeah, so that's what kind of the way we looked at it, is how we could use that fund and kind of not do so many road shows next year. I think it's part of our requirements that we do so many outreaches as a commission. So I know some of the other boards were not doing, I think we had like 12 scheduled this year, and the other commissions were doing 3. So
I think there were also times where you were in the car longer than you were actually presenting. So
yes, yes, I was.
So conceptually, to me, take the Austin McMullen model and have a simulcast, and do that 2 or 3 times.
Yes, I like that.
And the only thing, I mean, we just need to make sure for the fund purposes, if we're using the funds, that all licensees are aware that they can go to certain locations to watch the simulcast, and they're not going to be told, oh, you can't come in here. Or,
You have to advertise it. You have to market it.
yeah, so.
Because I think, we, like at our association, we had to cut it off because we were full. But you could have come from the Bristol Association or Morristown Association or any other association, as long as they signed up. You didn't have to be a member. You could just sign up, but you did have to sign up because of the limitation of space.
But it's a long ways from Bristol to Chattanooga, too.
I know. I know. That's
why
what
the simulcast
that's what
might
I'm
be a better
thinking.
answer. Plus, you could see it
I know.
anytime on YouTube.
So that's
I
what
like
I'm
that.
thinking about the attendance. So you'll go to the expense of renting a ballroom in Knoxville, and I don't know that how many people will drive, for example, for two free hours from Kingsport to Knoxville, and will the ballroom be filled up? I think they would go from, they would do it like I did my class. They would go.
maybe
and
even
watch it.
something where we did 2 in East Tennessee to really get, to get the Northeast, and then.
Because the
but
message
the
is
simulcast
wonderful.
is a good idea as well.
I think that's almost going to be the same in every area, because there are very few people that are going to get in their car and drive from Memphis to Jackson and vice versa, either way. What you will find is the smaller communities driving to the bigger, like people around Jackson driving, but you're not going to find those 2
I would love for us to push and ask that it be a simulcast like. That's what we would, instead of just saying, yeah, we're glad you're going to have 3, maybe 4, I would like for us to ask, could it be something that's simulcast? And so that then the associations can get their own people there. They'll help you market it. They'll get them there.
Yes.
And they're going to get credit. And then I would even keep it on YouTube. I would put it on, I wish we had our own website just for us where you could just put that on there so that if it's not convenient for somebody to come at that time, they could watch it anytime.
I think there is potentially a way to put it on our website.
Okay, that'd
Don't
be
quote
great,
me on
too.
that, but I think there's a way to put the link and embed it in our own website. They wouldn't be able to get CE because we'd have no way to verify, but they
were
would
at
be
their,
able to.
at their association.
Yes,
you can
yes.
verify it.
Yes, I'm more assuming that they just watched it on our website, but the
Right,
information
yeah,
would be
no
there.
CE for that.
Yeah.
Yeah, but, so if you did it, maybe broadcast from Nashville to 8 different marketplaces on May 1st, June 1st, and July 1st.
Wonder if I'd get 8 credits.
No, you don't. You can only get 2 credits in the calendar in the education year, but I bet you more people would show up for those, and if they had to travel hardly any distance.
And I bet you the Realtor Association would help you with that
Well,
because they have all the
came
equipment.
and they gave that presentation to us. I don't know if either one of you were here then, but they came and gave us a demonstration saying that they would welcome it and they would, I think they would be open to it for you to go over there, and don't you think, Austin?
Because they can ask questions even still.
They ask questions during my presentation.
Yeah.
We like that better.
We like
Like
the
it.
efficiency idea.
Yes.
Keeping people off the road. All right, Caitlin, what else in your report?
Just one last thing, and I think this is probably the way it's been, but I just want to mention it. I will probably be reaching out at the January meeting to go ahead and talk about the spring conference so that we can get the memo rolling and make sure that we're in good standing with the department on their at least 2-month in advance turnaround. For any of the conferences, I'll be trying to reach out at least 3 months before so we can go ahead and start talking about it so we can get the ball rolling on our end on reimbursements and those sort of things.
Questions?
Is that the Arello conference you're talking about?
There's the spring, yes.
Yeah. Okay.
So I'll be reaching out about that one in January at the January meeting, and then in the future, any others, at least 3 months prior.
Find that Arello list of the order that I mentioned it last month. There was a list, and we went in order so that not one person went every time, so that everybody had the opportunity at least to go.
I have not found that yet, but I
Could
think
be something that we might could put together ourselves.
and I didn't think about this, but I could probably get with our fiscal because they would have the record of
Okay.
reimbursement. So I just need to remember to do that after.
That's April 4th in New Orleans, too, the next one.
Most everybody here has been except Rick and Johnny. Is that correct?
Johnny
Johnny's
went to
been-
Louisville.
Johnny's been,
Johnny went to-
one, I think.
Johnny has been.
You went to one, though, didn't you?
You and
Have you
Gary
not?
then have not.
Okay, and Austin has not, have you? And
Gary has.
I
not.
have.
Because Johnny
Gary
and
Gary.
Marcia went to Louisville. Because I think Rick was, you were going to go to that, but you had your back surgery.
Yeah.
So, yeah.
Okay, Caitlin, a couple other things. By statute, we have to have a meeting in West Tennessee next year. We've got it scheduled for May, but we have no location, right?
Yes, and I have not had anybody reach out to me.
And so commissioners from the West District, would you all be thinking about that? If you,
I think you need to go back to Jackson again because we've had it near Memphis a couple of times. So Jackson's about the only person that's big enough. Their association and the surrounding is about the only one big enough to have it, with the exception of the Memphis area, I think.
typically, we found associations who have members on the commission are more likely to host than those that don't. So I know.
Jackson's very amenable, have
Yeah.
been in the past
Yeah.
to most things. Mhm.
All right, that's one thing.
You could call Janet, she'd line it up.
Yeah. Caitlin, you mentioned briefly about maybe getting the 2019 calendar, or at least meeting schedule done as, earlier than we typically do. How's that
Yes.
going?
So I can book the room as far out as probably the beginning of next year. And so if the second Wednesday of every month, except for the meetings that are out of town, works, I can go ahead and.
I would think if maybe next month you can bring us a tentative schedule for 2019. We might have conflicts, but I know Caitlin will check Arello and NAR and TUR. TUR. No. TRA. Was it TRA? Ms. Franks.
I also wanted to ask, were you able to get a temp for while Melissa is out, and is Melissa coming back?
Melissa is coming back.
Good.
Her original due date was not until November 30th, so this was a surprise to all of us. Luckily, we had gotten the temp approved. I think she basically started maybe a week after our October meeting, and so she has been with us now for a couple weeks. So she's getting up to speed on processing and helping us with some scanning and those sort of items. So she will be here, and then Melissa, I'm sure her schedule has changed a little bit as the baby came early, but I think we expect her to be back now probably closer to the end of February.
Okay, and I wanted to ask, has there been any traction or any more info about working from home?
We've started.
Okay.
So they are on week 2 of working from home. So far, so good. It's only been 2 weeks, so maybe at the next meeting I can have an update report for you guys on how it's going. So far, it seems like everybody is thoroughly enjoying not having to drive in, park. Most people are probably saving about 2 hours of their day that they were previously in the car. And staff seem to be processing faster. I know my inbox is quite full. So, but we have done a schedule where everybody's in the office on Wednesday, and there's never less than 2 to 3 people every other day.
My last question is, I was cleaning out filing cabinets at my office, trying to get rid of paper, and I had a file of the newsletters, the Trek newsletters, and I'm like, oh my gosh. I had written notes on them, and stuff like that. I wish there was some way, in electronics fine, I'm not saying to mail them to people like we used to, but we used to have them. I mean, it's only been in the last year or two that we've not had newsletters. And I think that's a great outreach, too, for people. And I looked in those, and it had in those newsletters even people who were charged with and found guilty of certain, not crimes, but what?
I just said violations.
Violations is the word I'm looking for. And that was a huge, huge deterrent.
Reminder.
It certainly was.
Yes, that is on my to-do wish list.
Okay.
And I'm hoping to maybe, ideally, January 2018 would be a good kickoff. I'm already writing down topics that I think would be important that we see on our end that people either forget about or don't know. There's definitely resources that I think people don't know about that they should know about. And I think a newsletter would be a great way to share those resources and sort of hot topics that we are hearing about. So it is on the to-do wish list.
Every month we have someone say, I didn't renew my license because I didn't get anything from Trek. And we know, but most people do not know that and it's been a couple of years, we haven't sent them out. But, I mean, every month we have somebody comes in. That's something that could go in the newsletter. as a principal broker, I'd surely be looking to that newsletter to see what was in it.
I'd like to pick up on that too, on those newsletters. It's not only important to know who did what in wrong, but what their offense was, because that's and what happened to them. That is really as big a deterrent as ever. And certainly, if people knew, for instance, if Gary had been charged with something 3 different times, they would say, okay, this is an issue. We need to watch out for things.
Especially if you're a principal broker and you had a contract
careful.
come in
right,
from
exactly,
that person.
because you need to. I mean, I tell you, that was just people go down the list and say, not only who but what they did. Well, we better watch out for that, so we won't make sure we don't do that.
Most people don't want to get in trouble.
No, most people don't.
I remember when I got my license, and I guess the way it used to expire before they changed it was that it expired when you got your license. So 2 years later, it expired when you got your license, and it was changed. And so now there's no rhyme or reason. When everybody's expired, everybody got a new date. And so it's not on your birthday, it's not on your, like your driver's license is on your birthday, but everyone got a new date that had no rhyme or reason. So it was not when you got your license, it's not on your birthday like your driver's license or anything. And surely we can't be the only licensed group. So nurses and geologists, and out of all the people, we can't be the only licensed group that
Doesn't send it to anyone, do
that has the same issue. I really wish we would come up with some birthday or something.
You're not the only commission that has this issue.
Oh, that's what I'm saying. There's got to be something, and you would think the state. We can't be isolated. We can't be the you would think the state, since that there would come up with something that makes sense that people could then remember.
I'm not sure when the change happened, but now, I mean, when you do apply, you do have the same date that you applied and were approved. 2 years later from that date is your expiration. I know some people, I think attorneys do birthday. I know accountancy does end of the year. Everybody's expiration is a 12/31 date. From an administrative standpoint, that's really hard to renew everybody at the same time.
Correct. Right.
And we have a lot more licensees than they have. But I do think my goal would be to do an electronic notification eventually. But we're not there yet.
Hey, Caitlin, one more miscellaneous item. As far as our October meeting next year, so we have at least 2 entities or locations that have offered to host in East Tennessee. And at some point, this commission has to make a decision on where you would like to have your October meeting in 2018. At the moment, Gatlinburg has sent a proposal. Do you think that's a formal proposal, or?
So I think I've had 2 formal proposals, and I did not come prepared with that information, mainly because I knew we had wanted to decide on the spring meeting, and I had somewhat left that, let's have a conversation when we've had the spring meeting figured out. I got another email, I believe from Diane is who's the head of your association?
Edith Ann.
I believe
Wadowitz.
she had reached out.
She
as well.
said she was.
Yes.
Okay. Good.
So, but I had kind of left both of those with. We are going to decide on the spring meeting first.
Okay. Just want to keep that on everybody's radar.
But if we remember correctly, it was Kingsport, then Farragut, then Chattanooga.
That's been the general rotation.
Right. Okay.
But there's no reason it has to be that way. It's just how it's been.
Gatlinburg sounds good too in October.
Really?
You hadn't been up there in October, have you?
Yeah, Gatlinburg.
All right, let's move on to commission discussions. Thanks, Caitlin, for your report. Diane, you wanted to talk about the Bill Toon Award.
Yes, as I age,
As
I age, I reflect on things, and this was I have had a birthday recently, and I've done some reflecting, and I would like to make a motion, and I'll tell you why. I'd like to make a motion that Bill Toon Award would be awarded to Russ Farah. I was thinking, I think he's approaching, if not already, 30 years. I think he has done an awful lot. I would be sorry to say if we let time pass and that we don't appreciate what he has done for all licensees. I know he does things for realtors, but it has always helped all licensees. And he has, the time I've been here and served on track, there have been times that we have needed help. We've reached out. He's been able to help us. I just as I aged, I just thought he would be a very deserving person, and I wanted to make that motion.
Okay.
We have a motion on the floor offered by Ms. Hill, seconded by Ms. Taylor, that the Bill Toon Award, before Diane forgets it, be awarded to Russ Farah. Was that what you were saying?
That is exactly what I was saying.
And I have a question.
Go right ahead.
What is the criteria for the Bill Toon Award? And when was it established? What's the history on the Bill Toon Award?
It's in policy. I'd have to go pull it during the break to give you the exact criteria.
You still have policy?
That is an internal policy that we're allowed to have.
Okay.
So
It was generally set up to recognize an outstanding educator. Diane can make the case strongly. I think that Russ has done a lot to educate a lot of people.
So not necessarily. In the past, it has gone to members of the commission. So it's not necessarily, it couldn't be someone outside of the commission then.
Sure. Yeah. As a matter of fact, it was kind of, I'm not going to say it's self-serving, but that's a fairly recent development where commissioners on their way out get the Bill Toon Award.
I'll grab that over lunch and bring it back down if we take lunch.
You want us to vote on your motion now? You should.
Up to you. Yes, sir.
That's what I thought, before you forget.
I do.
Before we all forget. Is there more discussion on the motion? Let's vote then. Those in favor vote aye.
Aye.
Those opposed, no. The motion passes unanimously. All right, track attendance. Was that yours, Bobby?
Oh, no.
No, that was Gary's. I'm
Yeah,
sorry.
Yeah. If I came to a meeting of the commission today, would I receive CE credit?
Yes.
And how many?
8 hours.
Is it 8 hours?
8 hours. Now, that needs to be advertised. We don't tell anybody that.
I've mentioned it at every one of my outreaches this year.
Well, we're going to have these 3 that we just mentioned. That ought to be on each one of those agendas. Sure.
It's also something that can be posted on the education page. Just kind of highlight that if you come.
Newsletter.
And the newsletter.
I think it provides a great educational service. I've not talked to anybody who ever attended one of these meetings that didn't feel that way.
I haven't been to the website lately, and I'm sure it's updated, but I found it very difficult to get information on before and navigate for me. Now, I know I'm an exception to the rule when it comes to websites.
I always have to Google track, and then Texas real estate comes up.
But it's hopefully on our website we make it user friendly where it's easy for people to answer get the answer to these questions and the knowledge that is easy to come by rather than having to spend hours trying to find how to get there, which I gave up even trying to find out how I'm compensated because I can't get on there.
Bookmark.
I am not doing it.
Come
I just
on.
forget it. I just wait for my bank deposit to come.
By the way, this meeting at the moment is being streamed live across the world, and you can watch it on the Trek website.
World Wide Web. www.
All right, Gary, we get your message on that. Any other comments about promoting Trek attendance and continuing education credit? All right, Bobby, you want to talk about business cards, advertising, not advertising.
Well, and this was done before I got on the commission, and when I teach core class, I get this question all the time. We have a list of things that are considered advertising, things that are not advertising, and business cards are not considered advertising. And I was just trying to figure out why.
So when I gave the presentation in Jackson, I had a prior commissioner there that was able to answer that question. And she stated that when they discussed these rules, they thought because business cards were so small and to make your advertisement so small and to include everything on it was impractical. So they included them in the not advertising.
I don't think that's a good reason.
And I was here then, and I wasn't for that either. It, to me, is advertisement when you're handing someone your card.
I understand that argument if it's an ink pen, all right?
Or a shirt. You can't get it all on a shirt.
But my argument would be if you take most of the real estate agents in our state, the biggest expenditure they have for advertising over the years is their business card. And they don't do a lot. There's a lot that don't do above that. I don't understand how that's not advertising, and why that wouldn't.
Are those paid for at a firm level or individual?
Depends.
Have you seen many business cards that did not have the broker information on them?
I've seen a lot of business cards that you have to really hunt for the broker name on them.
I've seen a lot of team names.
Yeah.
And their name and phone number.
Yeah. The team name is kind of down. We're about the same print as copyright information.
So it's not really a matter of that the business cards don't have the proper information. It's just it's not in the proper
They're not
font
required to
according
put their
the
office
rules
name
of-
on it even, or
Yeah.
the office phone number.
Yeah.
That to me is a broker issue because at my company we had one card, it had to be outlaid one way. That was it. You didn't have the choice. But there's so many companies now that just you do what you want to, put whatever you want to on there, and that is a mistake. It
There's
truly
lots
is.
of people branding themselves now too, and being encouraged by their brokerage to do that. So that's why I'm seeing a lot of team names that don't have their, and they're not required to at this point.
So, Bobby, you want to do anything about it?
Can I say that I would like for the commissioners just to think about it, and can we put it on the next agenda? Just say that we'll talk about it again and see if we want to take any action at that point. Or is that wrong? Or
No, we can certainly do it.
I just don't want to spring stuff on it. But that's the one thing that people continue to say. Why is that not advertising? And business cards, they're big enough you can get all the information on there.
So, I mean, it would be a rule change. So what we could do is I can send out a notification this month saying that it will be discussed at next month's meeting. That way, if people do have opinions, maybe they can send them in or come in and voice their concerns while we're discussing it. And then,
Well, my concern, and this is just part of my history, is that when you open something up, instead of just open up a little piece of it, it opens it up for all kinds of comments about all kinds of things. It could be a sticky wicket, in my opinion. I'm not trying to talk you out of doing this, but I'm just going to tell you, when we finally did get a definition of advertising codified, for lack of a better term, it was not easy.
I understand.
and it's going to look like we're adding another, essentially, restraint. And so that's what we need to consider is if we want to open ourselves up to that.
That's how it was brought to us. It was a restraint, now that you say that.
Because we would be going in and saying, okay, this is no longer on the not list, but is now advertising. So all of you that have business cards already printed that do not follow these, you're going to have to go back. And
Yeah, but business cards are not a lifetime purchase. That's a short-term thing. So,
So I said, let's put it on the agenda, and Sarah, if you will, advertise notice, however you do that, that we're thinking about it. Nothing more than that at this point. And maybe we can get some feedback between now and next month. Is that okay, Bob?
that's fine. Thank
Okay.
you.
Formal hearing schedule. Was that you, Gary?
Oh, yes. If you don't mind, I'd like to interject another thing. Mr. Cunningham came today, and I'm guessing that he was just ill-informed. That's what my guess is. But I've read notes several times over several months where people said that they called Trek and got this advice. Now, they may not have got that advice, but it'd be good, I think, if we had a meeting with all of your Trek employees and said, this is what we talk about and this is what we do not talk about over the phone.
I think, in that instance, and this is partially, I take responsibility for it. We have a lot of people that say, well, I don't care what the rule or law says. I still want to come.
I acknowledge that.
And so, on my end, I had somewhat assumed that that was one of those people. So I definitely think that there's a coaching lesson to be had. I had listened to Mr. Cunningham's phone call, so I know who he spoke to. So I think I can relay some of those meeting requirements that might not be being relayed correctly.
It just doesn't look good for us, for somebody to come down here and say, well, I was told I could appeal, and the rules are clearly that he cannot appeal. Okay.
But it's good it was recorded where that she could go back on it. That's most conversations. Is it true that most conversations that take place are recorded?
Yes. If you call through the means that we intend for you to call through, which is our main line, yes, it is recorded and there's a history. So I can see most people's interaction with our
Let them know they're being recorded?
In Tennessee, it's a one-party state, so you don't have to.
Are they transcribed to text, or is it save the audio?
Save the audio. And then, we also have the email correspondence, which would be text.
Okay, the real issue I want to talk about is like the hearing that's supposed to take place tomorrow. Is it possible that we could schedule 2 hearings at a time? I mean, I think judges do this all the time, where they say we're going to have a hearing tomorrow, and then the first one runs over and over and say, oh, I'm sorry, we didn't get to you. You'll have to come back next month. I mean, it doesn't look like it honors our time.
So Trek does not have a big backlog of litigation right now. So that's why we don't see so many set right now. I want to say we have less than 10 cases. And the reason tomorrow's was continued is a family emergency on behalf of the attorney that was representing the other party. And so it had to be continued.
I'm not complaining about that. I am complaining about if we have a backlog, we could have heard one tomorrow.
Well, and I can tell you what we've seen in the past is if we set 2 for tomorrow, you all get to stay here until you finish tomorrow. So if you have 2 hearings and one goes 7 hours and the other goes another 7 hours.
Oh, we'd just tell the second one
like
they do in court.
We have to finish them with the ALJ here because they're scheduled on certain days.
And who says that?
It's under the ALJ. I mean, it's with the ALJ. We'd have to talk to them. Because I was just telling Diane yesterday, a funeral case a couple weeks ago was given notice on a certain day and it went until 10 o'clock at night.
What about this notion that I think Gary's bringing up that if it's going to be rescheduled, how about checking with Commission to see what they think about that?
I mean, we can email you all and say there's been a continuance that's been requested. But even like when Robin got that continuation request, she can object to it, but the ALJ can still approve it. So even if we said, the Commission doesn't want to have a continuation, they want to hear it, the ALJ may say, this is their first request. Some of this is completely out of our hands. So I do know that they're trying to schedule hearings and things come up. So
generally, it seems to me if we have a hearing scheduled, there's at least a 50-50 chance it won't happen on the date it's scheduled.
Yeah.
How many do you think we've had this year? Not the, I know ALJ's here, some of them, but this commission itself has had 2.
I know you had the Collierville.
Collierville, yeah.
About every 2 to 3 months.
Yeah, so maybe 3 or 4 a year at the most, it seems like. Now, we have one scheduled in December.
Do we have a backlog?
No.
I guess it's,
No.
okay.
I don't want to beat a dead horse.
You made your
We don't-
point.
If
I'm
we
with
don't
you.
have a backlog, we don't, that's a non-issue, actually.
Okay. Austin?
If we had a backlog, we would be pushing for more to be set, and
Austin, discussion of meeting times.
I think we ought to talk about whether starting our meetings at 8:30 instead of 9 might be something that people would be interested in. I know start at 8:30, and that way they would have a 30-minute head start on getting back to the house. I think
Is that a motion?
Sure, I'll make a motion. Let's start our meeting times at 8:30.
I second it.
Is there discussion? Well,
How-
excellent.
How does that work for the state? I mean, it works really well for me. How does that work for the state?
Jerry, I don't know if you want to add any input from your standpoint, but I think,
She has to get the room ready and everything.
but I think, yes. So I think from our from our standpoint, there's nothing that we can't do in that allotted amount of time for the
Right.
meeting.
Now, my last question before we vote is, do those ALJs care? Do they only start at 9 o'clock in the morning? Or can we say it's scheduled for 8:30 and they can tell us, no, we're not going to meet until 9? Or how does that work?
I'd have to ask one of the litigators what the ALJ schedule is if it's 9 o'clock. I know I have auctioneers. We got a bunch of business done before the hearing started the last time. So if we can get in here at 8:30 and, get through the main points, a few things on our agenda, and then go to the hearing, and then we can wrap up at the end if we need to.
Like maybe in the motion it says 8:30 on our real day, and on the legal days, if we had to, be 9.
I'd love to give those ALJs some guidance and tell them we're going to do it at 8:30.
Well, and that's
And especially
fine,
the
too.
day they go home
Yeah.
after being here from a hearing.
All right, the motion is for future meetings, schedule the start time at 8:30 Central Standard Time. When in Nashville? All right, let's vote on the motion. Those
Wait a
in
minute,
fa-
wait a minute, wait a minute. When in
Starting
Nashville?
December or January?
Are you saying in East and West we wouldn't start
Well,
at 8?
let me rephrase it. The motion is to start at 8:30 a.m. local time,
Starting at the December meeting.
starting the December meeting. All right, those in favor of that motion, vote aye.
Aye.
Those opposed, no. That motion passes unanimously. Thank you, Mr. McMillan. Hey, we're going to take about a 7 or 8 minute break, and Lillian, we're ready for the legal report, and your attorneys need to get their cases down here.
That's a nice way of putting it.
We'll see you in about 7 or 8 minutes.
Put your case down here.
All right, let's get back to work. We are on the November consent agenda. Ms. Ryan, you're the senior member of the legal team here today, so you get to go first. You're welcome.
Did you say senior member?
I said senior.
Singer. S-I-N. Singer.
Okay. First, let me again explain what happened tomorrow is that we don't have a hearing because on Monday the attorney's father had a medical emergency and she had to fly back to Pennsylvania to take care of her father. And so as soon as I got the motion for continuance, I did send out the notice that this would not be heard. We set it for February. I should be back I will be back by then. I will not be present at the meeting next month. I will be recovering from surgery. I may or may not be available by telephone because I'm technically on sick leave. I will be available by telephone on the January meeting. I can't drive after my surgery for 8 weeks. And yes, thank you. That's exactly right. Yeah, it's pretty annoying. So, anyway. So, and again, let me apologize about that. That was a last-minute thing. Her dad actually apparently has Alzheimer's and had to be put in the hospital. Okay.
So the December meeting, who's the litigator? We have a formal hearing according to the agendas.
In December?
Yes.
Not with me.
Okay, it's not, there is a litigator, but not.
I don't know.
Erica, do you have a hearing set?
No, I don't think you do.
So then there's no hearing.
Yeah, the website shows we
Yeah,
have one,
so,
yes.
but neither one of them have one set, so I assume there's.
I don't believe there is. I don't think there's, there are a couple of attorneys that are still doing hangover track cases, but I don't think any of them have set a hearing for, I didn't mean, I don't think any of them set anything for December. I don't know if Erica will have one for January or not. She and I discussed about.
I plan on having one in January. I'm currently talking with. I plan on having one in January, and I was watching the meeting at my desk actually, and I heard you guys talking about possibly having 2 hearings in one day. So this case happens to be 2 complaints with the respondent and then, or I'm sorry, an affiliate broker and the principal broker. So something like that, I think would be really convenient to do in one day.
Well, I think you have to do them in
Well,
one day.
that's kind of my question.
I think what
Yes.
Commissioner Bloom was talking about was having like a first-tier setting and a second-tier setting. So if the first-tier case got continued for some reason, then second-tier would be ready to go.
But
I think that's what he was talking about. That's the experience that I've had in court.
to be perfectly
where-
honest with you, we don't have that many cases to be set before you right now. What we have are mostly cases that you won't hear, unlicensed cases. That's the majority of the cases we have in litigation. We have a small number of failure to supervise type cases. I don't know what her case is. But it's 2 people for the same thing on hers. The last time we did, I will tell you, the last time I did an affiliate and a broker on the issue of what the broker did and the failure to supervise, we heard both cases at the same time because really they were so related, it was easy enough to do.
We had a backlog at a period of time.
We did.
But
We
I guess
don't.
we've worked through that, and so
Yes,
we're in
we
better
did.
shape now.
If we get to the point where we have cases that we have to get on, I think we could put 2 cases on so long as there's not an attorney. If there's an attorney on the other side, I'm going to tell you right now, we're not going to get finished in a half a day, and that's just the nature of the beast, of the attorney beast. Not me, or Austin, or her, but all the other attorneys. In any event. But we don't have that many right now, which I'm glad to say we don't have that many. And a lot of what we have are unlicensed cases. So that is not something you all are hearing.
Well, Erica, you
And
did.
by the way, Mr. Bloom, just to let you know, tomorrow's case would have gone all day. We wouldn't have been able to have a backup case for it. It's that serious for the person involved, that they're serious about it, and there is an attorney, and with the witnesses that they are calling, it would have gone all day.
But again, I think what Mr. Bloom was talking about was if there was a second-tier setting, then the second-tier case doesn't go forward if the first-tier case goes forward. But if there had been a second-tier case set, then when the first-tier case got continued, second-tier goes from being on deck to being up at the plate.
And you know, when the people are here in Nashville, that might be possible, but when they're not from Nashville, I don't think that's fair or possible to bring them in on a second tier. Because if they come in and then the case is, not continued, and they're sitting there, it doesn't seem right to me.
I can tell you it happens in state
circuit
court and federal court
Yes,
all
it
the time.
does.
And it
does in
also
circuit court.
could be a person that we've revoked or suspended a license on that would like to get their license back pretty quickly.
Well,
too.
and we try
Something
to
like
take that in
might be-
consideration as well. If there's somebody that is pushing for a hearing, we do take that consideration when we're trying to set them. But if there is inappropriate, if we have cases that are appropriate, we can do that. And I do think that Eric and I look at them that way, so that, yes, but I hesitate asking an attorney to come and put that on their docket and then find out at the last minute they're not going to go forward. I hesitate to do that when there's an attorney involved, but that's me.
If there's not a backlog, then it's not an issue
Yeah,
right now.
we don't have a backlog.
Okay, let's get started on the consent agenda. Ms. Ryan, as I said, you start this off.
Yes, I do have the consent agenda. My cases are 1 through 23. I can go ahead and read the numbers in unless there's anything anybody wants to discuss.
Let's see if anybody wants to pull anything out of 1 through 23.
I wanted to pull 22.
Okay. Any other items? Mr. Wood?
Let's pull 23 out.
22 and 23. Other complaints? All right, Ms. Ryan, we're going to let you read those 1 through 21 into the record, the case number, then I'll entertain a motion to approve council's recommendation.
Thank you. Number 1, 2017-032751. Number 2, 2017-032771. Number 3, 2017-032951. Number 4, 2017-032871. Number 5, 2017-032891. Number 6, 2017-033391. Number 7, 2017-033411. Number 8, 2017-034511. Number 9, 2017-034571. Number 10, 2017-034651. Number 11, 2017-034421. Number 12, 2017-034441. Number 13, 2017-035121. Number 14, 2017-036041. Number 15, 2017-036081. Number 16, 2017-036391. Number 17, 2017-036411. Number 18, 2017-036431. Number 19, 2017-036451. Number 20, 2017-036481. Number 21, 2017-037161.
Recommendation is to dismiss each of these cases.
That's correct.
Yes,
So
sir.
move.
Motion by Mr. McMullen, seconded by Ms. Franks, that council's recommendation be adopted and these 21 cases be dismissed. Discussion. Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. The motion passes unanimously. Okay, we pulled out number 22 and number 23. Are they related?
No.
Okay, let's go with number 22, then if you read that into the record, please.
2017-038171. Anonymous complainant states respondent is practicing without a principal broker and has been for more than a month. Complainant states respondent is being run by a new agent, an affiliate, and the developer. Respondent states respondent was operating within the 60 days allowed to operate without a principal broker and filed for an extension of 30 days, which was granted. Respondent states that at time of this response, a principal broker is in place and that respondent was not being managed by a new agent pending the principal broker being placed, but by an affiliate broker, the developer, and an attorney. Rebuttal from complainant states that respondent did not let TREC know within the 10-day requirement regarding the loss of the principal broker, and this was checked right before complaint was filed. Complainant states that the developer thinks developer can work without following rules. There is nothing in the allegations to support the allegation that anonymous complained. No dates, times, or anything else to support this complaint. The respondent does have a principal broker, and there is nothing to suggest this was not handled properly except the statements of complainant.
Good. Not me.
That was me.
Marcia, sorry, you've got the next one.
So what I'm wondering, first of all, can you operate a firm for 60 days without a principal broker?
You can get an extension under the law. You can ask for an extension of time to operate without a principal broker when there's the, let me find this exact section of principal broker here, which they did.
Okay. Got a blue book?
I do.
Okay. Yeah, just if you could tell us what page when
Yes,
you
as
get
soon
to
as
it.
as soon as I find it, I'll be happy to tell you. Must be up here. Absence is in the rules. Commission must be notified.
What page are you on?
I'm sorry, on page 95. Commission must be notified within 10 days of the death, resignation, termination, or in capacity of a principal broker. The Commission may, in its discretion, based on the merits, permit a real estate firm to continue operating without not to exceed 30 days. If within 30 days a real estate firm contacts demonstrating their compliance, the executive director had the mandatory to grant a 30-day extension. So as far as I know, within TREC, they followed the rules here to ask for the proper extensions.
And so they did get the extensions?
As far as I know, they got the extensions.
Okay, so where'd you get that information that they got the extensions?
That's what I was in the file. You can answer better than I can, Caitlin.
I have not looked at this particular file, and I would assume that it probably was before my time, but we would be able to probably confirm within the complaint file.
And would that extension have come from the real estate commissioners?
Would have come from the program. Them.
I think that's. I think we need to know that.
Well, as far as I can tell from what's in the complaint file, they were operating with the complaint being granted by the program.
And they put that in writing that they were.
They put that in writing.
I don't like. And first of all, it wasn't the principal broker didn't leave, or there was a sickness or a death. They opened up a company and didn't have one.
No. It was already. It's not an opened up company. It's an established business.
But can't we just ask the office to take a look at that maybe during lunch, and then we can solve this one right after lunch, real easy? Is that okay?
We'll postpone a decision on number 21, 22, and go to 23. Bob, is there a particular issue with this?
Yeah, if I recall this one right, this was the one where maybe people went to a new home site, and the builder made them sign a piece of paper saying, you agree now, you don't have an agent, and if an agent comes back, we're not going to pay them.
No, they have documents that say no. They had to inform if they had an agent when they came to the. They came to the site several times before an agent was involved in this at all. And
apparently didn't have an agent.
They did not have an agent. They didn't have an agent for the first several times they went out. Okay. And they were given the documents say, please tell us, do you have an agent? And they did not have an agent. So then, their documents say, you didn't bring it to us. They came by themselves. That is why you don't get a commission at this point, because you're too far along in the process. They went several times before that.
But I don't think they had signed anything. I mean, they hadn't signed a contract.
They hadn't signed a contract. They were given the documentation that said that, though, that they were asked if they had an agent and signed a document saying they didn't have an agent at that point, because they didn't.
And they were told, you can get an agent, but we're just not going to pay them.
Well, they could get an agent. They could have informed them in some part in the process. This agent didn't become involved till like third or fourth or fifth step in. That's when the agent became involved. The agent did not show the place at all. The agent did not do any of that. They did this on their own over months, and then an agent got involved.
You're calling step. Was it before the contract was written? Because a lot of times
it was before the contract for building was written.
So apparently the buyers had some interest. They kept going and kept going away, kept going and kept coming back, and then finally they come back with an agent.
Yes.
And then they're ready to try to do something.
Right.
And they're saying, we'll let the agent represent you. We're just not going to pay them.
The commission. That's exactly right. Because their documents, they said, and each time they went was basically, their documents, internal documents say, who was the originating persons that got these persons interested in the property? Was there an agent involved that brought them to this new home site? Did this person bring the business to us, basically?
The argument's over procuring calls, right?
I'm sorry?
Procuring calls. It's basically whoever sets up a series of non-ending events that result in the contract.
Yes, and all the documents were provided to the buyers that said that, basically. If you have an agent, let us know. Please let us know who the agent is. And then the documents also say in there, yes, if you were the person that brought us to us, that's one thing. And if we were told about it beforehand, that's one thing. But at this point, we are not paying a commission.
So really, the complainant should be addressing this with the builder, because it was the builder's rule the realtor has to abide by whatever their seller wants. So it's really not even a real estate question in my mind.
I don't think it's a real estate question either, and I don't see anything unethical about it either, but although if there's an ethic violation, that's not us anyway. But it seems like it was pretty clear on the front end, this is how we're doing business here.
I know several builders that do that.
Yeah, I was not surprised to hear that.
Like it, but they do.
Yeah. Because this is a money issue.
I guess I don't look at it as an ethics problem. I look at it as a procuring cause, but I don't think that's. I think that's more of a association event rather than a real estate commission
By
event.
definition, procuring cause is a money issue. I mean,
it's a what?
It's a money issue. I mean, that's when
It's a court
Okay,
issue,
yeah.
probably not a commission.
Okay.
We don't handle money
Okay,
issues.
I'm good. Okay.
Is
It,
there a
just,
motion?
it smells funny. I just didn't like it, but it's I don't think it's anything we do here. Okay.
Move to dismiss.
But we maybe didn't
Second.
read the number in, did we?
Okay. Motion and second to dismiss.
I've got that. Ms. Hills makes a good point. Robin, did you read the case number in?
I did not.
Would you do that before we
I'd
vote?
be happy to. Case number 2017-038281. Do you want me to read into? Okay, thank you.
All right, that's the motion is to dismiss. The motion was made by Mr. Woods. I'm sorry, Mr. McMullen, second by Ms. Franks. Or Wood, Miss Wood.
1 and 2.
Okay, I got it. McMullen and Wood. Let's vote on the motion. If you're in favor, vote aye. If you're opposed, vote no. That motion passes unanimously. Thank you, Robin, Erica, 24 through 48. Before we get started, let's see if we have commissioners who'd prefer to pull some of these out.
Sorry, I know y'all want to go fast, but
No, that's okay.
24, 25, and 26 all have to do with the same case, and I'd like to pull those.
24, 25, and 26, okay. Anyone else?
I had the same ones.
Okay, Eric, if you'll start with number 27, read the case numbers in, we'll entertain a motion once you've done that.
27, 2017-032071. 28, 2017-032091. 29, 2017-033091. 30, 2017-033071. 31, 2017-033211. 32, 2017-033231. 33, 2017-034761. 34, 2017-034341. 35, 2017-034361. 36, 2017-034281. 37, 2017-034301. 38, 2017-035091. 39, 2017-035691. 40, 2017-036271. 41, 2017-036101. 42, 2017-036121. 43, 2017-036161. 44, 2017-037821. 45, 2017-037841. 46, 2017-037891. 47, 2017-031321. And 48, 2017-031341.
Motion by Mr. Wood to accept council's recommendation and dismiss cases 27 through 48. It was seconded by Ms. Franks. Before we vote, just a technical point, Erica.
Numbers.
Reference numbers 6 and 7, when in fact, they're not 6 and 7 in our final.
Yes, sir. I was actually going to bring that up. They're actually 29 and 30. I apologize.
I just want to make sure the record reflected.
And I've had Rihanna has actually fixed the the version the final version will reflect these changes. I apologize. I won't.
That's not a problem. You know how it happened. All right, the motion in front of commission is to dismiss cases 27 through 48. Any further discussion? Let's vote. Those in favor of that motion vote aye.
Aye.
Those opposed, no. Motion passes unanimously. Okay, on 24, 25, and 26, Marcia, is it, you want to give us global? What's your
Yes,
concern
there,
about
there are,
global?
these are all three, does she need to read in the numbers or anything first?
Well, let's
Okay.
just talk about the issue first.
These, all three are unlicensed allegations. And Erica's interpretation was that they were owned by this person. But in fact, he says they were in his LLC. The first meeting I had was January 2015. And on that day, we started talking about an LLC. And I did not know that an LLC doesn't have the protection that corporations do in negotiating and buying and selling property, even if it's your own property. Our family is developers, and at that meeting, I had to recuse myself because I was sitting here knowing my husband was out doing that very thing. So we've had to, he was. And so we've had to change everything now that we have that information. And when I questioned it, Eve Maxwell was the director at that time, and she said we had an attorney general's opinion on that. And so during our lunch break, she went upstairs, got a copy of that attorney general's opinion, and I have since floated it to everybody that asked me a question about LLCs. I know we have personally other lawyers who don't believe that that's the correct interpretation, but I'm going by what the Attorney General said and feel that that should be our interpretation as a commission. So there's been several of these LLC problems that have come before us, and we have always looked at that Attorney General's for what we should do. So the first one was a, let me get back to it, they're all three unlicensed. The first one was this man saying, I have an LLC, I can sell my own properties. The second one, they're saying the manager, they filed a complaint on the manager. Now, in an LLC, you have a chief manager of the LLC. So I'm thinking that could be one and the same person, since it was, I don't know that, but when they say manager, I think that's what that means. And then in the third one, let's see. I don't remember what I thought. This respondent's response to the complaint is exactly the same as the response explained in case number, you see that on 26?
Yes.
So all three of these are about this LLC and this person claiming he doesn't have to be licensed to sell his properties.
Yes. I actually brought a bunch of documentation because I thought that these three might come up, and I talked with the respondent from number 24, the owner of the LLC, at length. The manager from number 25, there was one complaint filed, and the complaint makes allegations against the respondent in 24 as the owner of the LLC, says there was a manager and names that person, but I can't find any evidence of this person even existing. The owner of the LLC says, I don't know who this person is. Everything that the complainant sent me, the owner of the LLC says, those are not my leases. Those are not, I don't know where those came from. The manager's name is not anywhere to be found on any of the documents the complainant sent, only initials that match that manager's name. But it's definitely not someone that works for the LLC. I even Googled this person. I mean, I can't find, I'm not sure. And I also I emailed the complainant, called the complainant, and explained that, you know, you presented me with 81 pages of attachments to your complaint, but you didn't provide proof that you own these properties or that you bought these properties, as she alleged. And I explained that if you can't present that information, that I have to recommend dismissal because the respondent has provided all the documentation showing he owns it. And she never has responded to me. So I'm only left with basically no contact information for the manager. I don't have any way of getting...
So it's not the owner of the LLC, is not the chief operating manager?
Well,
he should know who that person is.
Well, he's the owner of the LLC. They run apartment units, and that's all they do. He says he owns all those apartments through the LLC, and that's all the LLC is for.
But the documents show that the LLC owns the property.
Yes.
Not him
The
personally.
deeds, yes, that not him personally.
And that's where I'm going with this. It's not about the rents
That's
to
the
me.
crux of the matter.
It's that you have someone who thinks they don't have to have a license, and the charge is unlicensed. This person is unlicensed, right?
Yes.
Okay, so he cannot sell his own properties, even though he has them in an LLC.
It's not his own property.
They are,
It's
even
the
if he
LLC's
owns all of the stock in the LLC.
Okay.
So,
And the LLC is not a licensee.
right,
Yeah.
right.
In the LLC is the respondent in number 26.
These three complaints, one is against the guy who allegedly owns the LLC, one's against an alleged manager of that LLC, and one's against the LLC.
Right.
Okay.
One single complaint.
Right.
So, but the owner of the LLC knows. We have lots of LLCs. I know who the chief manager is on all of those. He knows who the chief manager is. He was just, hoping that you didn't figure that out, I think. He may be the chief manager. If so, really there's only one. I can see how we would only find him guilty in number 24. 25 is just redundant, I think.
Well, 25 is obviously you can't see the name of the person, but the name of the person is just a separate woman that has nothing to do with any of this. It was just named in the complaint, I think, by mistake. So there's no manager that was named in the complaint for us to have opened a complaint against.
Oh, so 25, I see that we can dismiss that one. But now 26, so this is about the property management company.
Yes, the respondent in 24.
Which is also unlicensed.
Yes.
All right, so they're saying they have a property management company and they're unlicensed. That's a violation. They're also saying they have a LLC and they don't have a license. That's a violation. So I make a motion that we dismiss number 25.
Let's stop there.
Okay.
Would you read 25 into the record, the case number?
24 is the LLC guy.
25 is 2017-032221.
Your recommendation is to dismiss. Is that your motion?
Yes.
Motion by Ms. Franks to dismiss, second by Ms. Hills. Discussion on that motion. All right, those in favor of the motion vote aye.
Aye.
Those opposed, no. The motion passes. That leaves us with two outstanding, 24 and 26. Which would you prefer to take next, Marcia, or do you want to combine them?
To me, 24 and 26, and y'all chime in on this. We can find the person who's doing this in the name of the LLC. That's one person, but he also has a property management company. Is that what you're saying?
I think the complainant said the LLC was a property management company, but once the respondent responded, he said, no, this LLC is just an entity that I opened to buy these apartments, and rent them out, and that's all it does. It doesn't manage anyone else's properties. Only
Does he have, does
the
he,
units the
did he
LLC
collect deposits, security deposits?
yes,
Okay, there you have it.
yes.
Okay. So,
I'm looking
Feel free
for
to
Did
make
he
a
own-
motion.
Does
I'm
it
looking
matter
for
that
it.
the LLC owned the properties that he collected the security deposits on? That doesn't matter.
still a property management
62,
company without a
13.
license.
Okay.
6213-104.
So, but the bottom line is, the owner of this LLC thinks he, because he owns the LLC, can sell, buy, property manage, and
Property of the LLC.
property of the LLC. My sense is, you could, I'd be in favor of voting to say that's true on one of them, but not both, because I think it's probably the same case twice. That's just me.
Well, managing property, even
Microphone.
if he as an individual owned it, if it's over 4 apartments, that puts it in a whole different.
And it's
ballgame.
14.
Yeah, so, to me, he's
Opinion.
guilty in both cases.
Okay, so I'll make a motion, that's on number 24. You want to read that number in, or?
24 is 2017-032201.
Motion.
I make a motion that this person is unlicensed and that we, okay, now the fine, though, I mean, the civil penalty. Before I make my motion, can we talk about that?
Sure.
All right, so we know there's 14 properties, right?
Yes. And since then, I'm not sure if this matters, but since then, he has sold them all. The LLC nor him owns anything anymore. But at the time of the complaint, yes. There were
But he could have a
14.
new LLC.
He
We don't
says he
know.
doesn't, but I don't know that.
All
for
right,
sure.
so I just don't know what the will of this commission is as far as what the penalty.
Well, look at page 10, so E and F.
He did tell me he is 75 years of age and is wrapping everything up and will not be doing this anymore, if that matters.
All right, I make a motion that we find that they are unlicensed and they're practicing without a license, and that we fine them $1,000. You can do it per day, you can do it per,
Violation.
I'm giving a little leeway because if they're not doing it anymore, if they've closed it, I mean, I can only take their word for that. But
So this,
it's open to discussion.
this is just for number 24.
That's just for number 24.
Okay, we have a second. Second by Ms. Taylor. So the motion, if agreed to, would offer civil penalty of $1,000 to the respondent. Is there further discussion?
But we have to have the rule number, which Diane.
What's unlicensed activity? What?
It's 62-13-301 is the license requirement.
That's good. That'll work. Yes, Gary.
In 24, were they managing these properties? Was he managing these properties? Because if he wasn't managing properties, we're hanging all this on an attorney general's opinion, which is in conflict with the state, actually. I mean, there are a lot of attorneys that don't believe that.
But the Attorney General is who gave us the interpretation, and since January of 2015, we have relied on that consistently.
The same AG still in place?
No.
Maybe.
But nobody's
Okay.
challenged his opinion.
I mean, and who was it that requested the opinion?
We did.
Real Estate Commission.
You should know, though, that since then there was one hearing wherein we had the same set of facts and wherein we lost before an administrative law judge. I ended up resolving that by reaching an agreed order, but the administrative law judge also agreed. Not that it means anything, but just to know that there are going to be different opinions on all that. You just need to know that.
You have 12 lawyers, you got 12 different opinions.
I
Or
was just-
12 people.
And when they write the opinions, do they give the rationale? I mean,
I
or
can
they
go-
just say, this is my opinion?
I can go print it and
Yeah,
bring it
they
down.
give the
if you-
rationale.
The issue in that particular case was not quite the same. It was whether or not the LLC was entitled to the same definition as for corporation in the statute, and the answer was no, it's not. It's not a corporation.
I would just like to have a better understanding of why. I mean, whatever their opinion
And
is.
they
what,
tried
you know,
to
but I can
change
just-
that this past year in
Yeah.
the legislature, and it
Didn't go
didn't
through.
pass.
And it did not pass, yeah.
All right, let's get back to the topic. Gary?
I'd like to hear from Austin.
Got the Attorney General's opinion. I think it's hard to go against it until you have a court that says otherwise.
And to Marcia's point, we've been consistent in our interpretation.
And I think, Gary, we're asking the question, were they doing property management? I kind of got the feeling that's kind of where it started, because they were saying, well, you didn't transfer all the deposits over. There was a new property management company. And so I got the feeling that was the problem. They were managing these that they sold, and then the argument came over rents and deposits and stuff.
And that's how I felt until I got the respondent's response and all of his documentation. And after I read it, it truly seems that the complainant just manufactured everything. And when I explained that this will most likely be dismissed if you can't just send me copies of this, and just no response whatsoever. So,
But the respondent told you that he was
he owned them
and the LLC, and he was negotiating and selling and things that you have to have a license for.
Yes.
May I ask a question of you, Marcia? It's okay if I
Yeah,
ask you?
sure.
Back when this opinion was made and you found this information out, and you guys, personally rearranged the way you were doing business, what would you have thought if the commission at that time had fined you for $1,000 for something that you thought you could do, and you were unaware of the Attorney General's opinion at that point?
It's why I recused myself that day, because
Yeah.
I felt like I was sitting here guilty of that. My husband was guilty.
The reason I'm asking is if that's his opinion. As Austin has stated, I guess we need to go with that opinion. But I'm wondering if the $1,000 fine might be a little too much. Maybe a letter of warning would
Well,
be
there's
more
no letter of
appropriate.
warning because he says he's not doing it anymore.
All right, let's get to the motion on the floor and see how it goes.
Yeah.
Okay, the motion, if agreed to by a majority of this commission, will offer a civil penalty of $1,000 for a violation of statute that requires a license to do certain duties. Let's see what a voice vote sounds like on this. Those in favor of that motion vote aye.
Aye.
Those opposed, no.
No.
The motion passes on a 7 aye, 1 no vote. Mr. Douglas votes no. Okay, 25 we've handled. Number 26, Ms. Franks.
I guess I'd like to see what the opinion of the group is, whether we find that the LLC itself was unlicensed, or do we just lump it all together in that one?
What's the difference between 24 and 26?
Well, the 24 is the LLC's owner, and 26 is the LLC itself, which is now dissolved.
LLC wasn't engaged in practicing real estate without a license because it was the LLC's property, right?
Well, yes.
Oh,
That's
yeah.
what.
I moved to just make that one.
Motion by Mr. McMullen, second by Ms. Franks at number 26. Would you read that case number into the record for us?
2017-032181.
Motion is to dismiss per council's recommendation. Any further discussion? Those in favor of the motion vote aye. Those opposed, no. That motion passes unanimously. Now, just so I'm correct, did we pull one out to get an interpretation later this afternoon?
Yes.
Number 22,
That's
right?
correct.
Okay, just want to make sure we have that when we come
I mean,
back.
I do have that information if you want to.
You have it?
I have an information, and these are the dates, and I can't tell all of it. There was a request made, and there was I don't know if it was first or second request for 30 days. It was made. There was their broker unexpectedly left, and they promised to have this was in one date. This person was taking a test, and that person was going to be in place by July 30th, which was another 30 days there. So as far as I can tell, the requests were made.
And they were granted the extension, is the question.
Yes, they were granted the extension.
And it says that on that piece of paper?
Well, no, this is the letter to us. This is what
Okay,
we
that's
have
a
in the file.
request, not an extension
Well,
granted.
The firm's license was never withdrawn.
It was not withdrawn.
So it must have been granted, is how I would look at it. All right, is there a motion to?
And this is an established business, by the way. This is not a new business at all. This is well established. And this particular entity and the people involved in this entity have been before you many times.
And I would tell you that this time period was when we were without an executive director. So I believe
Not a principal broker.
it's kind of like the same thing.
Lots of rudderless ships out there.
But I would assume
And by the
staff granted.
And by the
that.
way, you should know your new executive director appears to be doing a very good job.
Let's not
She's
get off
very
topic
good to
just
work
yet.
with.
The motion is to accept council's recommendation and dismiss.
Who made that motion?
Item number 22.
I did.
Okay.
Mr. McMullen did, and I think Mr. Douglas seconded it, as I
Okay.
recall. That's what I thought. So let's vote on that motion. Those in favor say aye.
Aye.
Those opposed, no. The motion passes unanimously. Okay, ladies and gentlemen, it's just a couple minutes after noon. Let's come back at 1:15.
Oh.
And we're going to hear Erica's report first. won't we?
No.
Okay. Back to the legal report. Who's going first?
I think that's me.
All right, Ms. Ryan.
Number 1, 2017-033541. Anonymous complaint with a picture of a sign stating for sale commercial lot with a phone number. Complainant states phone number is for respondent and that this is an advertising violation. Respondent states property with sign belongs to respondent's spouse and sibling. Respondent states that there's not been any other advertising in this property. After speaking with the respondent principal broker below, respondent removed the sign. Respondent states that as the property belongs to spouse, respondents would direct, it said could, but would direct all correspondence to spouse, but states that if property is still to be sold, all advertising will be done through the real estate office. My recommendation there was a letter of warning.
Move to accept council's recommendation.
Second.
Motion by Ms. Frank, seconded by Ms. Hills to accept the recommendation of a letter of warning. Discussion.
When you said that the sign was the sign of the spouse and the sibling,
If the property is the spouse,
okay,
not the sign said for sale property with a phone number. No name, no firm. It was on the property in question, nothing else but that, for sale. And it happened to have that respondent's phone number on it.
so it had the affiliate's phone number
Yeah.
on it.
Was that phone number his wife's number?
No, it was
As well?
his phone number.
Okay.
But he said that he would direct all calls to the spouse on, if they came in on that number. But he wasn't, I think he put his number on it, was just easier to do it that way, is what he said. Having said all that, one sign, no advertising anywhere else, nothing but the sign with the phone number on it. And after speaking with his principal broker after this, they removed it entirely. That's why it's a letter of warning, I think.
And I don't require my agents that they have to have, if they sell their home, that it has to be through Franklin Realtors.
But it wasn't his property.
But it's his spouse's property.
Oh,
Yeah.
had his, okay. It was only in her name.
Well, spouses and siblings,
Yeah, that's,
Depends on how she got it.
I don't, as far as I could tell, there was nothing to do, there was no expectation of commission, there was nothing but a sign with his number on it, for the benefit of the spouse and the siblings for this piece of property, and that's it. No other advertising, no names on it, no firm, nothing, absolutely nothing. And as I said, it was removed. This is why I'm suggesting a letter of warning.
All right, any other questions?
I think I'm okay with this. We'll cut this.
All right, let's vote. All those in favor of the motion, please say aye.
Aye.
All those opposed, vote no. That motion carries unanimously. Number 2.
2017-033-561. Respondent states that respondent above recently moved license to respondent's firm. Respondent states that after receiving this complaint,
Move to
respondent...
dismiss.
Second.
Motion by Commissioner Frank, seconded by Commissioner Wood to dismiss. Discussion.
I wrote myself a note. I've got to look at this right quick. I'm all right. My question was, did she or he have interest in title? What, I don't know. We don't know that, so I'll go along with dismiss.
Okay. Any other discussion? Let's vote. All those in favor of the motion, please vote aye.
Aye.
All those opposed, vote no. That motion carries unanimously. Ms. Ryan, number 3, please.
Also an anonymous complaint regarding advertisement on Facebook. Page lists Blum 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 Group at Blum 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 Realty with a phone number and address, but did not have full firm name and did not have statement as provided in Rule 1260-02-124B. Each franchise trade name or corporate group office is independently owned and operated. Respondent states that though name had to be in conjunction with group name rather than only in contact section. Respondent states page was updated to show firm address and firm number in contact section. Our review online shows the page has all the requirements of the rule, meets all the requirements of the rule in question. Therefore, I recommend a $500 civil penalty for the violation, initial violation of Rule 1260-02-124B.
Motion to accept council's recommendation.
Second.
Motion by Commissioner Hill, seconded by Commissioner Taylor to accept the recommendation of a $500 civil penalty. Discussion? I thought we got rid of that each office.
You did. This is just prior to that.
Oh, okay. And would this have been subject to the one-click rule, or was this before that too?
It would, and I can't tell you whether it satisfied or didn't satisfy that one-click rule because by the time I got it, it was already resolved.
So your recommendation, there are 2 possible violations, but your reference is just to one of those?
Just to one of those, that's right.
Which one is that?
Okay, hold on just a minute, I'll read it to you. 1260-02.
I think the rule number applies to each office independently owned and operated.
Any licensee using a franchise name or advertising as a member when advertising other than specific properties for sale or lease shall cause the following legend to appear in the advertisement. Each franchise name or trade or move will be operated.
So you're not recommending a civil penalty for advertising without the firm's name?
No, because they changed that right away, and it was implied. It's just that the franchise name was more prominent. Let me just explain. These several complaints were all from one anonymous person complaining about various pieces and there wasn't a lot to go on, and so I did my best with what we have. And as I said, it was resolved by the time I got it in any event.
But
I mean, you could dismiss it. That would be fine with me. I don't have to do a consent order then.
I don't want anybody to feel, though, that, I mean, I'm okay with anonymous complaints and understand why people would want to do it anonymously. I wouldn't want to, for us to make it look like we weren't accepting of those. Because
I agree.
I encourage people to do it, even if they have to do it anonymously.
I do agree. I just wish sometimes if you're going to do it, you give me everything I
Right.
need, because if...
They can't talk to you
Right.
to find out what they need.
That's right.
Ms. Robbins, so the recommendation for the civil penalty is for violation of a rule that no longer exists.
Oh.
It did exist
You
at
say it
the
no
time.
longer exists. It existed at the time in question.
Right, but no longer.
Is that true? Where is...
Where is Sarah?
Wait a minute. I have it.
Wait a minute, I do too, come to think of it.
I
think I have it.
I have it too. I'm sorry I didn't act more quickly. 4. Now it says, any franchise using a franchise, license using franchise name of business art, contracts, or other documents relating to real estate transactions shall clearly and unmistakably indicate his name, firm name, and firm telephone number. That's the new rule.
Would it be possible?
Go ahead, Gary.
Well, I just wonder if the maker of the motion would accept a substitute motion.
Made the motion.
Commissioner Hills?
Yes.
Mr. Bloom?
I'd like to make a recommendation that we send a letter of reprimand.
All right, there's a substitute motion to send a letter of reprimand or warning. Is that the same thing?
Well, no, it's a letter of warning.
Letter of warning, is that okay with you?
Sure.
Mr.
Okay.
Bloom? Okay, is there a second to that
Second.
motion? Seconded by Commissioner Wood. All right, so the current proposal is to send a letter of warning. If that motion is approved, then that will supersede the motion for the civil penalty. Discussion on Mr. Bloom's motion of a letter of warning. All right, let's vote. All those in favor of the motion vote aye.
Aye.
All those opposed vote no. That motion carries unanimously. Number 4, please.
2017-033601, same anonymous complainant as above. This complaint included a picture of a sign on a property listing, and that sign did not have the firm phone number listed. Respondents state that the sign and property in question were in another state listing, and that the phone number listed was submitted in an application to the state of Tennessee for initial firm license. Respondent states in speaking with someone at TREC about a firm name change, respondent was informed that only one number can be registered with TREC for primary firm number, and that once firm number name processed, marketing materials will reflect one number and new name. Sign in question is in another state and may comply with that state's advertising rules. However, the number should have been the number that associated with the firm. Therefore, my recommendation was a $500 civil penalty for violation of the Rule 1260-02-12-3B.
Motion to accept council's recommendation.
Second.
We have a motion by Commissioner Taylor, seconded by Commissioner Franks, to accept council's recommendation of a $500 civil penalty. Discussion.
So was the sign was in another state?
Yeah, and sign and property were in another state.
How can we punish somebody for a sign in another state?
Well, you're right, except that we are saying this person has a license in Tennessee and the office in Tennessee is, you're right, that's a good question. But they were doing work cross-border, and as I said, another state's rules may be different. It still reflects on that licensee, although in the state of Tennessee. So that's why I was recommending such a small, put the firm name, phone number on it, regardless.
So it would really be up to the other state
If there was a violation.
if there was
for
a
them.
violation,
Uh-huh.
not us.
That's kind of what
I think.
Can I offer a substitute that we dismiss?
All right, we have a substitute motion by Commissioner Wood to dismiss. Is there a second? Seconded by Commissioner Franks. All right, if this motion passes, it will supersede the civil penalty motion. Is there additional discussion about the motion to dismiss? Let's vote. All those in favor say aye. Aye. All opposed say no. That motion passes unanimously. Number 5.
2017-034661, complainant is licensee of same ethnic background as respondent. Complainant states respondent had internet advertising in both English and ethnic language, but that the terms in ethnic language were, why pay extra? We'll help you sell your house with fixed commission $3,000 and you save the rest. Not only that, but also we'll help you buy a new house and we'll take only $3,000 rest of the commission to be for helping you in your closing costs or toward your down payment. This ad had name of principal broker phone number as well as respondent's name. Complainant states respondent is inviting ethnic community to pay them any amount above $3,000 and is trying to impact this community. In a companion anonymous complaint, the complainant states that Facebook ad is posted in 2 languages, with the English saying respondent will charge a flat fee of $3,000 to sell and will give buyers the rest of the commission towards closing costs, but that the ethnic post states that the charge will be a flat fee of $3,000 without mentioning closing costs mentioned in the English post. Respondent states the English version states, why pay more? I will help you sell your house for a flat fee of $3,000 and you save the rest. Moreover, I will help you buy your new house at a flat commission $3,000 and the seller will credit you the rest prepaid towards your closing costs. Respondent included the ethnic version. Respondent states it is legal to agree on a flat commission with clients to list a house with no cash or kickbacks were mentioned. Respondent states complainants want to ruin respondent's credibility in the community. Respondent's principal broker below had the ad translated as follows. Why pay more? I will help you sell your house for a flat fee of $3,000 and you save the rest. Moreover, I will help you buy your new house at a flat commission of $3,000 and the seller will credit you the rest prepaid towards your closing costs or down payment. Principal broker advised the statement to be revised to read, "Why pay more? I will help you sell your house for a flat fee of $3,000, and you save the rest. I will help you to buy your new house at a flat commission, $3,000, to allow the seller to sell you the home for less, or to allow them to pay you some of your closing costs or upgrades." This may be confusing, but does not appear to violate the gifts and prizes rule or to be an offer of paying commission to unlicensed persons. But it is confusing and should be corrected. 2, the handling of this matter caused the principal broker below to release respondents so that there still does remain conflict and confusion. My recommendation was a $1,000 civil penalty for violation of 6213.312.4, misleading advertising.
Second.
Motion by Commissioner Taylor, seconded by Commissioner Hills for a $1,000 civil penalty. Discussion.
I think there are a lot of issues here, for one.
Speak up a little bit if you
I
don't
think
mind.
there are a lot of issues here. First
Okay.
of all, how can a agent promise what the seller or won't do with the rest of the money?
Well, maybe
That's-
the seller told them what they would do.
Well, maybe so, but I just think this is misleading and the wrong way to go about it. Let's
Okay.
put it that way.
Commissioner Grease?
Did you see the advertising in?
But I can't translate it.
Well, that's why I was going.
Yeah.
So we don't know who's telling the truth here, do
That's
we?
right. But there is confusion, and there's no question there is confusion, and it caused issues. And it does appear, even from his own translation, it probably wasn't as clear as it should have been. I cannot tell you what it says in the other language, but it does need to be corrected, which is why I recommend the misleading advertising violation civil penalty.
But if we can't read it, I got a problem with that. I mean, we don't know if it was misleading or not if we can't read it.
I have translations that say otherwise, that seem to indicate, as I have, the translations are in there, but I can't read it. I
Right.
can only rely on what the translations say.
When you say translations, are you saying Google or the respondent's
Different
translation?
individuals translated it. Don't-
Do we have anybody here that can translate
No,
it?
we don't.
So,
No, but I'm seeing this a lot in our area. And I don't want to say what ethnicity, and I even really kind of hate that word is in this, but there are people from a country who are realtors, licensed, and they make deals with other people. They usually go to the same church or whatever it is that they go to, and these are like they bring somebody once a week from their church, and they cut their commission, and they use that commission to pay towards closing costs. The seller allowed it, so
I just
Could we get Avaz or our service that we use for in-person translation?
maybe.
I don't
But
see that
I
there's. I don't see that there's really. I don't understand the dispute about the translation. I understood it to say I'll charge you a fixed fee of $3,000 and you save the rest, and that whatever the difference is will help you pay the closing costs or something like that.
The seller will,
Well,
not
but it
the
said that
agent.
the seller
And
will
the seller will credit
it.
you the rest
That's
as a
the misleading
closing
part of it. The
cost.
seller will credit you.
but
the
that's
rest.
not misleading because
What-
our seller says yes, we can do that.
Was there a?
It
Did
was
they
a
provide a seller that didn't do it?
It was not that kind of. It was a Facebook advertising generality. So this is where it's confusing. So in reading it, you would assume whoever the seller is, that's going to happen. There's not a particular property in question that this relates to. It relates to all the transactions, which is why I'm saying that is confusing and misleading.
If it's not the same property, if it's not stated in the property.
And it isn't.
Specifically.
Which is why I'm saying I think it should be addressed and cleaned up at this, which is why I said that. If it were a particular piece of property, that would be a horse of a different color, but it isn't.
But they didn't bring in a transaction where somebody said,
there's
he
no-
told me that he would charge me $3,000 and I'd get the rest as a credit, and he charged me $3,000 and I didn't get the rest as a credit.
No, there was no
That didn't
transaction.
happen.
No.
Somebody else from that same church that's wanting to get those people.
To me, it looks like a shot that was fired that didn't hit anybody.
Well, you are
But that's
you
my
are
opinion.
welcome to do that. I mean, my concern was, as I said, it wasn't a particular piece of property. It was on this advertising, and it is a bit confusing. You could do a letter of warning. You could dismiss it. You could lower the penalty. That's up to you.
I think the wording is misleading, saying the seller will pay. How does he know the seller will pay?
If there was one property, it'd be
It's possible the
different.
seller would pay, or something like that, but I think it's totally wrong.
My issue is that's the translation, but I don't know if the translation's correct.
Well, and it may not be, but they both have the same gist as the seller will pay that. So that's somebody speaking for somebody else. You can't do that.
I think if there's any doubt in our mind that we have the right translation, I think we would be wrong in passing judgment on something that we're not even sure about the wording. That's my biggest problem with it.
You have to understand, though, the respondent provided the respondent's own translation as well. And the respondent's translation says, why pay more? I will help you sell your house for a flat fee and you save the rest. Moreover, I will help you buy a new house at a flat commission of $3,000 and the seller will credit you the rest prepaid towards your closing costs.
And that's totally legal if they have one seller.
Yes.
But if you've got proof that that was just
It was just.
he wasn't representing one property, then that's different.
It was a generic advertising.
On Facebook.
On Facebook, yeah.
And in the next case, the broker had it translated.
Broker did. Well, I had that on here as well, the broker's translation.
That's next.
All right, the motion is for a $1,000 civil penalty. Are y'all ready to vote, or is there a substitute motion?
I'd like to offer a substitute dollar
Okay.
amount for
Mr.
$500.
Grease.
Second.
All right. We have a substitute motion for a $500 civil penalty made by Mr. Grease and seconded by Commissioner Franks. I think we've talked about it. Let's vote. If you're in favor of the $500 civil penalty, you'll vote aye.
Aye.
If you're opposed, you'll vote no.
No.
It appears that the noes have it, unless somebody wants a recorded vote. All right, we're back to the $1,000 civil penalty. Anybody want to vote on that or just offer a substitute motion? Let's go and vote on the $1,000 civil penalty. All in favor of the $1,000 civil penalty, vote aye.
Aye.
Opposed, vote no.
No.
All right, that motion fails. Let's get a new motion.
I'd like to make a motion.
All right, Douglas, make a motion.
That we just give a letter of warning to clarify the advertising.
Second.
Motion by Commissioner Douglas, seconded by Commissioner Franks for a letter of warning. All in favor of that motion, vote aye.
Aye.
All opposed, vote no.
No.
That motion carries with 6-2 with Commissioners Taylor and Hills voting no. Is that correct?
Yes.
Okay. Number 6.
Okay, 2017-034681, respondent.
Skip to the last paragraph in your recommendation.
There's nothing to show that this respondent failed to supervise, and when respondent continued to have problems with how this was handled, respondent properly released affiliate. Therefore, my recommendation is to dismiss.
Move to accept council's recommendation to dismiss.
Second.
Motion by Commissioner Franks, seconded by Commissioner Hills to dismiss. Discussion? All in favor, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Number 7, please.
2017-037121, complainant is tenant and respondent is property management company. Complainant states complainant was a tenant for 3 years and had paid a $900 deposit. At a walk-through inspection, complainant signed document that complainant would have to pay certain monies for changing locks and lawn care and paid to have the carpets cleaned. Complainant states complainant was called and told that, complainant was going to be charged to replace carpets, repaint 2 rooms, and an ozone machine, none of which was on the signed walkthrough. Complainant then requested a copy of deposit showing when deposited and what interest earned, and was told deposit was in a non-interest-bearing account. Complainant states respondent terminated conversation and was told complainant would be sent a statement with all the bills. Complainant states complainant left the home in a good or better condition, even having left thermal shade window treatments and a microwave. Complainant attached the walkthrough document with the charges listed for the keys and landscaping and 0 listed for cleaning and carpet cleanings. The statement then sent to complainant had additional monies listed for excessive wear and tear and carpet painting, ozone for soak smell, and a refrigerator handle replacement for a total charge of $488.08 of the $900 deposit. Principal broker for respondent answered complaint. Respondent states that 2 inspections were involved in process, and this includes a move-in inspection, but that inspection was never returned. At the move-out inspection, office manager was present but had to refer to a recorded move-out from previous tenant as the baseline for the damages charges. Carpet cleaning and a rekey charge are mandatory, and tenants are responsible for upkeep of property. Concerning the property, respondent states complainant was charged for excessive wear and partial replacement for only one room, and charged for painting of one wall in kitchen and one in living room. The ozone machine was to remove smoke odor, and states all tenants are informed smoking is prohibited and charges would follow if rule is ignored. In the previous move-out, one room smelled faintly of smoke, but no ozone was ordered. A complainant had to move in quickly, and since the complainant was also a smoker. Complainant was only charged one half of the amount concerning the bank information. One half of the amount. Concerning the bank information, respondent states no one is given free access to bank records, and when complainant was informed, complainant became verbally abusive and call was terminated. Respondent states that the tenants are informed that any change in structure must be removed at vacancy, and the window treatments left by complainant were not properly hung, but complainant was not charged for removal nor the removal of the microwave. Respondent attached a copy of the walkthrough document, but this document has heavy wear listed next to carpet, although it is the same document signed by the parties provided by complainant. No lease agreement was provided to show that the property is non-smoking, that carpet cleaning and rekey charges are mandatory. My recommendation was a $1,000 civil penalty for violation 6213-4034, failure to provide services to each party with honesty and good faith.
My concern, I think this is an issue between a tenant and a landlord. I think these are civil issues. I don't think they're real estate commission issues.
Well,
That's kind of my thought.
Okay.
I mean, my motion would be to dismiss.
All right, we have a motion by Commissioner Wood to dismiss. Is there a second? Seconded by Commissioner Taylor. Discussion.
Just,
Mr. Grease.
Is there evidence that the walkthrough form that the complainant had was different than the one the respondent?
Yep.
That's where I would like to focus.
That was my focus. The one that the complainant signed at the walkthrough did not have those notations on it. The one respondent provided had that heavy wear on it as to back up for the reasoning for charging the extra money.
And they had signed it?
No, it was the same document. Exactly the same document. It was added after the fact.
I believe the respondent added it after.
I do.
But I think in the Landlord-Tenant Act, the landlord has up to 30 days to find issues with the property. It's not you look at it to the walkthrough and it's over. They got 30 days to catch stuff, and that could happen. You do a walkthrough, and then you catch stuff as you go in and start repairing and getting the property ready for the next people.
Well, I'm sure you're right. The problem is it's exactly the same document that was signed by the respondent and the complainant at the date of the move-out, and then that document was altered later. That's the problem I personally have with it.
And you can't add the items above the signature.
I'm sorry?
You can't add the items above the signature.
Once there's a signature.
Yeah.
Without some
Exactly the same signature,
explanation.
the same date, it's everything. It's the same document, but it was modified and altered later. That was the problem I had with it. I agree with you on the landlord-tenant. I do agree with you. The problem is, for me, was it representation from this licensee who gave this person at the time, here's what it is, and then later altered it to show something different. That was the problem I had.
This
That
property-
doesn't mean that there wasn't heavy wear and tear.
Is this property in a county that the Landlord-Tenant Act applies to?
You know, I actually don't know that offhand. I didn't look at that because I wasn't looking at the Landlord-Tenant Act issue, to be honest with you. I look now and find out what
That's
county.
different than statewide?
No, it's
It is a
not.
state law, but it doesn't apply in every county.
No, it doesn't apply to every county.
Just the large counties.
Is that really relevant since the additional stuff was added to the document after the signature was on there? I mean, I think I see her point. I mean, it's providing services to each party with transaction with honesty. I mean, it's not honest to add stuff to a document after the signature's already been there.
All right, the motion is to dismiss. If you support that, you'll vote yes. If you want to do something. All those in favor of the motion to dismiss, vote aye. Yeah,
Is
I'm
that
sorry.
the motion?
The motion was
Not the
to
motion.
dismiss.
Yeah, I made that motion.
Oh, you made that
I did
motion.
that.
The motion was to dismiss.
But if you want to do something different, go ahead.
Let's go ahead and vote on that one, and then we'll
Okay.
see, okay? All those in favor of the motion to dismiss, vote aye.
Aye.
All those opposed, vote no.
No.
I had 3 yeses on that. It was Taylor, Wood, and Bloom. Did you vote yes
Yes, I
to
did.
dismiss? Okay. So that motion failed 3-5. Is there another motion?
Move to accept council's recommendation.
Second?
Motion by Commissioner Grease, seconded by Commissioner Franks to accept the recommendation of a $1,000 civil penalty. All in favor of that motion, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Number 8, please.
2017-036311. Complainant is is lessee, and respondent is management. Complainant states that respondent is keeping deposit and has not supplied an accounting or explanation. Complainant states when complainant moved out, the house on April 15th was clean, the carpet was professionally cleaned. Complainant states lease states that failure to schedule a walkthrough could result in forfeit of deposit, but the walkthrough was scheduled but could not be done to various circumstances. Complainant states keys were returned through attorney, and the complainant spoke with attorney because complainant did not move out March 31st per lease terms and had to attend court for an eviction. Ahead of the court, complainant states the rent was paid, and in court agreed to pay more money because the move-out was not on March 31st. Respondent, through attorney, states complainant was given notice on February 14th that the lease was not going to be renewed. Respondent states complainant agreed to be out of the home at lease end March 31st, and complainant did schedule a walkthrough. On March 15th, complainant asked for a 6-month renewal and was advised that fixed month leave was not available. Complainant states complainant did not move out by March 31st, and a detainer warrant was issued on April 4th. At the time of the hearing on April 17th, complainant had moved out, paid for March, and brought the keys to court, but then owed April rent and was liable for court costs and fees per the lease agreement. Respondent states respondent and complainant agreed to the April rent plus the 150% holdover per lease, and that deposit was not refunded as complainant forfeited it under lease terms. Lease provides that failure to schedule a final walkthrough and or return keys will result in forfeit on deposit, and further provides that deposit may be used to remedy tenant's default in rent or other matters. Complainant did schedule a walkthrough, but that walkthrough did not take place for reasons not expressed by either party, but it does seem to be circumstances of complainant. While it would appear that respondent could be entitled to the deposit, a reading of the lease only states that walkthrough must be scheduled, so a better approach would have been to interplead the funds. Respondent was represented by an attorney who opined the deposit was forfeited. Therefore, my recommendation is a letter of warning.
Move to accept council's recommendation.
Second.
Motion by Commissioner Franks, seconded by Commissioner Hills for a letter of warning. Discussion.
Why are we warning them?
Because they should have done, because the lease says all you have to have is a schedule, not that it has to take place. And if they're going to hold on, and if there's an issue there, which they are saying, we're still entitled to it, I think the best thing would have been to interplead it, and I think that in the future they should have done that.
Did their lease agreement call for it had to be interpleaded?
No, the lease agreement said that in order to get your money back, you had to schedule a walkthrough, which was scheduled. That's all it said. And the respondent is saying, yes, but we're still entitled to this because it didn't go through and because of the fact it did not go through and because of other issues. And therefore, since there was a disagreement about that, I personally think the smart move would have been to put the money elsewhere and say, let's go fight about it someplace else, instead of just reacting. That's why I sang a letter of warning, because I'm not sure they weren't entitled to it, but I am saying that when you read the lease agreement, that's all it says.
The lease said if you
Schedule a
don't comply with the contract, like moving out and stuff, then
No.
you're going to forfeit
No,
your
the
deposit.
lease said that failure to schedule a walkthrough and or return keys would result in forfeit on the deposit. That's what the lease says. That's what they were relying on, both parties.
And this was 5 days after that.
I'm sorry?
They didn't move out until 5 days later, right?
No, they did not. They scheduled the walkthrough, though. The lease doesn't say anything about that. We're talking about just the deposit and the deposit alone, which is why it's not clear. You can see it's not clear to all of us. The lease deposit talks about, for one thing, that the reason they gave was that schedule of the walkthrough did not take place, but it was scheduled. The lease just says schedule. It's a little ambiguous on how you would interpret all of that.
And it doesn't say who canceled the walkthrough either.
No.
So there are no issues about the condition of the premises?
Well,
It's just because it didn't actually occur, they're trying to keep the deposit?
that is what I could understand, that they were that was part of, well, they were in default on the rent, and they didn't move on the forfeit, which is a different story. And that was a court order thing. The issue was the first part of it, how they paid the extra 150%. So they paid per the terms of the lease if they were evicted. And the issue now is the deposit. As far as I can tell, the only issue is the return of the entire deposit based on that.
And if
So they weren't using the deposit to set off against unpaid rent or repairs to the premises or
Well,
attorney's
at the
fees for
time of the
eviction or
hearing,
anything?
that the complainant moved out, bought the keys, but owed April rent and was liable for court costs and fees per the lease agreement. And they agreed to the April rent plus 150% holdover per the lease. And that the deposit was not refunded, and that they say it was not refunded pursuant to that section saying the walkthrough was not scheduled.
But they weren't forfeiting the deposit in order to pay the 150% rent and the court costs? and
No, no. This was in addition to that.
When they didn't comply with the lease agreement and move out, I
That's
think they
true.
forfeited that
Yeah,
deposit.
they went 15 days before they moved out.
That's true. The issue is the lease agreement and what both parties were relying. That's why I said a letter warning, because it's not clear, okay? And that's really what I'm saying, because the lease agreement, what both parties are relying on is saying scheduling the final walkthrough would entitle to you not getting your deposit back. And one party is saying it was scheduled and canceled, and therefore you're not entitled to. The other party is saying it was scheduled. And I'm saying I don't think they would have gotten the deposit back, but I think that that lease needs to be a lot clearer, which is why I'm saying a letter of warning or a letter of instruction.
I'd like to offer a substitute motion that we dismiss.
Motion by Commissioner Wood to dismiss. Is there a second?
Second.
Seconded by Commissioner Douglas. Okay, so the motion is to dismiss. If that were to fail, then we would go back to the original motion of a letter of warning. All in favor of the motion to dismiss, vote aye.
Aye.
All opposed, vote no.
No.
That motion carries on a 6-2 vote with Commissioners Taylor and Hills voting no.
Hey, thank you.
Looks like numbers 9 through 15 are representations that have to do with civil or some kind of litigation monitoring. Is that correct?
Most of them.
And then the last one, like it was something else, I thought.
Yes, that's correct.
So is there some reason that we're having to reconsider all these ones with litigation monitoring?
Yes, because
Okay.
things have changed since they were presented the first time around.
Okay. And that's just different circumstances in each one?
Yes.
Okay.
I'm sorry.
Okay.
2014.
You have a question?
No.
Okay.
I'm surprised you were asking questions like that.
000141.
Full of tricks.
The following information was presented at the June 2014.
Can you skip to the original recommendation,
Yes,
decision,
the original
new information?
recommendation was a consent order for litigation monitoring, which was, you all voted to accept the recommendation of legal counsel. New information, licensee below who was involved, this one was a failure to supervise. Licensee below who was involved has an expired license. Original attorneys in this matter have withdrawn, but new attorney filed an appearance for complainant in late September, but no depositions have taken place. No date for the trial is set. Respondent attempted to schedule a deposition with complainant in July, but got no response. This was the second request. My recommendation was dismiss the respondent below and keep this matter in litigation monitoring in event something is revealed that shows a violation of the Brokers Act, although in reading response, it does not appear there was any violation.
Just for clarification, this complaint number 9 is against the principal broker for failure to supervise
Yeah.
the broker in number 10.
Yeah.
But number 9 still has his license? This
Number-
principal broker?
Yeah, number 9 still has a license. Number 10 expired in 2014.
So is there any reason that we would dismiss, and why would we not be monitoring the legal?
With respect to the principal broker?
Right.
Because he still has a license.
He still has a license, that's correct, but the issue is going to be, if the issue solely against the principal broker is failure to supervise. Solely, that's the sole issue. Now, you could, but I think the underlying litigation is not. If the other person were still licensed and I could rely on them for being available and et cetera,
Cooperative and
all of that jazz, that's exactly right, I think I might be in a different position. But they've been expired since September of 2014. Cannot renew.
But it seems like, to me, I understand dismissing it when the person doesn't have a license anymore. But here, the principal broker still has a license.
Yes, the principal broker still has a license, but the only issue is a failure to supervise, and it's based on the next, if you read all of it, on what the respondent did below in all of this action, period. You can leave it open. I had there, we could keep this matter in litigation monitoring in case something shows there's a violation of the Brokers Act. I personally don't see it, but you can leave it open for the principal broker.
I move that we leave it open for the principal, on the principal broker.
Second.
Motion by Commissioner Frank, seconded by Commissioner Hills to leave number 9 in litigation monitoring.
It'll be
as to the
another 2 or
principal
3
broker.
years. I just want you to know that.
Leave it there.
I'll be gone.
I will too.
All right. All those in favor of the motion vote aye.
Aye.
All those opposed vote no. No. That motion carries 7-1 with Commissioner Wood voting no. Number 10.
2014-010521. Move to accept council's recommendation.
Second.
Motion by Commissioner Grease, seconded by Commissioner Hills to accept the recommendation to close and flag due to the respondent not renewing their license and the license being expired. All those in favor vote aye.
Aye.
All those opposed vote no. That motion carries unanimously. Number 11, please.
2014-007761. This was originally.
Skip down to the recommendation, decision.
The initial decision, recommendation was to put this in litigation monitoring consent order. The commission voted to accept the recommendation. New information, this matter is still in criminal litigation, and a jury trial is set for January 22nd, 2018. However, since this was presented, respondent's license has expired and cannot be renewed. If respondent is convicted, he would not likely be able to reply. Therefore, my recommendation is to close and flag.
Motion to accept council's recommendation.
Second.
Motion by Commissioner Hill, seconded by Commissioner Taylor to accept the recommendation to close and flag. All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Number 12, please.
2014-007821. This is the principal broker involved above. The original recommendation was.
Move to dismiss.
Second.
Motion by Commissioner Frank, seconded by Commissioner Hills to dismiss. All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Number 13.
2017-018941. This was originally presented in September 2017, and it was a litigation monitoring consent order, which was accepted by this commission. New information, the civil litigation was dismissed by the plaintiff.
Move to dismiss.
Motion by Commissioner Frank, seconded by Commissioner Taylor to dismiss. Any discussion? All in favor, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Number 14, please.
You guys are going too fast for this old lady. 2017-018961. The following.
Move to dismiss. Second.
Motion by Commissioner Frank, seconded by Commissioner Taylor to dismiss number 14. Discussion. All in favor, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Number 15, please.
2014-006311, originally presented in August 2014. The recommendation was for consent order for litigation monitoring, which was voted and accepted by the recommendation of legal counsel. New information, the matter is still in litigation. Respondent is in retired status. My recommendation at this point is close and flag should respondent attempt to come out of retirement and litigation makes findings of the violation of the Brokers Act.
Move to accept council's recommendation.
Second.
Motion by Commissioner Frank, seconded by Commissioner Hills to accept the recommendation to close and flag. All in favor, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Number 16, please, Ms. Ryan.
This is a correction on the number. It's actually 2014-029071. The original consent order called, and it was presented in April 2015. The original consent order asked for $2,000 for unlicensed activity in violation of TCA 6213-103 and 6213-301, and in order to do cease and desist on unlicensed activity. The commission authorized a consent order for $12,000 in unlicensed activity for violations of the same act, and in order to include cease and desist. New information. This matter was set for formal hearing concerning the 6 properties in question and has been continued. Respondent hired an attorney who provided documentation to show that respondent was a trustee for all of these properties through a trust, giving all power and authority to trustee as if an owner. Also, after this matter was first presented, respondent did secure a license. All documents show that respondent was acting in position as trustee for all properties in question at the time in question. The definition in the Brokers Act for trustee only states that a trustee must be acting under a trust agreement, which was provided for each of these properties. Therefore, my recommendation is to dismiss.
Move to dismiss.
Motion by Commissioner Frank, seconded by Commissioner Taylor to dismiss. Discussion, Mr. Grease.
When did commission last hear this case?
2014. Oh, wait a minute, 2015.
So we offered a consent agreement at that point, which the guy challenged or lady and said, we want to have a formal hearing. So has it taken that long? That's kind of my question to get.
It has. In all fairness, well, you know I like to work fast and get rid of things, but we've had a lot of dynamic changes internally. The various cases were with different attorneys and were reassigned, and that was part of the problem.
When did it?
I filed this for a hearing this year, though.
When did the attorney provide documentation that?
Oh, I got that when we got into the litigation process. There was litigation initially showing the trust agreement for some of the properties, but I didn't have it for all of them. And what we had then was only what we found online, and I have all the documents showing this particular respondent was a trustee in a trust agreement at the time for each of these, when each of these came forward. That was provided to me.
I believe that. I just think
I don't know
somebody
why
could have provided that to you long time ago, and this been taken off.
I agree. When they hired an attorney, they got smart.
When was that?
I can't tell you that.
Was it this year sometime?
Yeah, we've been working on it since then. Yeah.
My thought was, I was just wondering, when did that trustee agreement get drawn up? I mean,
Before the sales.
It didn't happen about 2 years after they got in trouble?
No.
Okay.
No, the trustee agreements were all well before any of this happened. That's the first thing I checked, that it wasn't after effect. No, they were all there before any of it happened. Yeah. And this person is now a licensee as well. So that's the other part of it, which I don't know what
I
this
don't know if
person is
that
doing.
makes me feel good or bad.
I think they don't want to pay $12,000 for unlicensed actors.
Yeah.
Well, yes, probably not.
Did they not realize they were a trustee back when they?
Yes, they did, and they said they were a trustee.
They just didn't have the paperwork?
They didn't have all of it provided to us. Only portions of it were provided to us.
Motion is to dismiss. Discussion? All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Thank you, Ms. Ryan.
You're welcome. That's the end of my report. I will not see you next month. I will hopefully at least speak with you in January.
Good luck on your surgery.
No, thank you. I'll be hopping along Cassidy.
Hope
for a
you
while.
have fast recuperation.
Thank you. Appreciate it.
Smith, are you ready?
Yes, I am.
Okay. Number 17.
2015-022-4251, and this was presented in April 2016 and put into litigation monitoring at that time, and then presented at July 2017, and then again in September of this year. And the new information: counsel spoke with respondent since the last meeting and was presented with respondent's side of the story for the first time. Respondent had to follow the direction of the firm's attorney and was forced to settle in the civil suit and respond to this complaint as she was advised, but never admitted to failing to disclose adverse facts that she had knowledge of. Complainant contacted respondent more than a year and a half after closing to request a copy of a previous potential buyer's inspection report that complainant was made aware of. Respondent states that there were never issues with complainant's transaction, closing, or any correspondence between respondent and complainant after closing until complainant requested this report. It is important to note that neither respondent nor complainant had requested this inspection be done, and it had nothing to do with complainant's transaction because a previous potential buyer requested and paid for it. Even though it was not respondent's responsibility or duty to provide a copy of a previous buyer's inspection report, respondent wanted to help complainant and spent a lot of time trying to go through old files and emails regarding the previous potential buyer's transaction, and was able to provide complainant with the inspection report that respondent actually requested. And I'd like to just specify that it was a structural engineering report that she was able to provide, which she felt was more helpful than this inspection report that she didn't have.
Respondent simply did not have access to the inspection report that a previous prospective buyer had done, and that is the reason it was not made available to complainant. Respondent and her principal broker had no knowledge of any material adverse facts that may have been present in the previous potential buyer's inspection report. Counsel finds no evidence that respondent had knowledge of or failed to disclose material adverse facts and recommends dismissal. So the new recommendation is to void the consent order approved at the September 2017 meeting and dismiss the complaint.
Motion to accept council's recommendation.
Motion by Commissioner Hill, seconded by Commissioner Taylor to dismiss. Discussion. Commissioner Franks.
I have a question on the previous buyer. Were they represented? Was this company representing the seller then?
Yes.
Okay, so the realtor, and this happens, the realtor didn't want to have any knowledge of what the inspection said, right?
Yeah, that was
Basically.
their argument, when I presented at the last meeting, yes.
Okay. Okay.
My interpretation, I'm sorry. My interpretation is, and I remember this all 3 times probably, and I think if the respondent had ever responded, it's believable. I think the fact that they never really responded made it so suspicious.
Right,
So,
and that's how I felt, but
so I believe this.
I think the firm's attorney chose what to put in that response.
Which was poor.
Right, and it was truly out of the respondent's control, according to her, which it makes sense to me. If your firm attorney is telling you what to do, you have to follow that. And once she got the consent order and realized this is real, she stood up for herself at that point, and that truly was the first time I got to hear anything that made any sense or was a response.
So here, I have a procedural question. So we took your advice last month, the month before, and so the complainant and the respondent both knew what our action was. Subsequent to that, the respondent gives you additional information which causes you to change your recommendation.
Yes.
Does the complainant know that at this time?
That I've changed my recommendation? No.
And to me, just a sense of fairness would be to say, hey, guess what, complainant? I'm going to try to open this back up based on new information.
I agree with you, and I asked if I could do that, and I was told I was not to tell the complainant that I had changed my recommendation at this point.
Now, if I remember right, and I'd have to look for it, complainant had asked for it to be withdrawn?
Yes,
on
as
one
part
of
of
the
a
times
settlement.
before?
Yes. She said, basically, the respondent's firm drafted a letter. She signed it as part of a settlement.
She wanted this
Yes.
complaint to be withdrawn?
So I'd like to move we defer this for 30 days. I'd like for the complainant to go, hey, it's all good. I'd like to know that. Rather than just a respondent all of a sudden showing up with some story that may or may not be true. I don't doubt it, but I think in sense of fairness is the complainant ought to know that we've reopened the case.
Because does the complainant, the complainant usually gets a copy of the respondent's response?
Yes, always.
So the complainant has not gotten a copy of this response? Respondent's response, maybe.
I think normally that's sent out through centralized complaints. So
Right.
if it came directly from you and, you
Right.
didn't forward it on, then I would say
No,
they don't have a copy of
but
this.
Just that,
Yeah.
I talked with management about that extensively because I was worried about that, and I was just advised and told that I was not to share that further.
Motion is to continue this number 17 to the December agenda. Is there a second?
Second.
Seconded by Commissioner Wood. The motion was made by Commissioner Grease.
But it had the stipulation in it, you want the stipulation of that the complainant be told, not just it be, we're not just waiting 30 days, are we?
They're told we have new information. They don't necessarily have to get the information of what the new recommendation is.
Just provide the response and,
Yes.
and allow them
Yes.
to rebut.
Yes.
And then, so at the December meeting, I would summarize the rebuttal.
If there is one.
If there is one, or if not, I will just state that there's not.
As long as you tell me, hey, we let the complainant know that we've reopened this and asked for their additional input and they chose not to give some, I'm cool with it. I just want to make sure that not only this case, but anytime we reopen a case that's been really contested, this has been a tough one for a long
Very.
time. But I'd like to know that everybody's on even footing.
Does everybody understand the motion? Let's vote. All in favor, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Number 18, please.
2015-022-4271, and this is a represent. This goes along with number 17. The respondent is the principal broker for the affiliate broker in number 17. Would you like me to read the new information? It's pretty much the same as what I just read.
Well, no.
No,
okay.
let's wait till next month on that one also.
Yeah,
then.
I think Commissioner Franks makes a motion that we continue this to December meeting and provide the additional information to the complainant so that the complainant has an opportunity to rebut any of the additional information, correct?
Yes.
Is there a second?
Second.
Seconded by Commissioner Woods. All in favor of that motion, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Number 19, please.
I just want to make a statement about number 19, number 20, and 21. The order of these is not probably the best for you to understand the allegations. Number 21 is the only summary that actually addresses the allegations. Would it be okay if I read that first?
Go ahead.
Number 21? Or?
Well, is your recommendation litigation monitoring?
For all three, yes. I only mentioned the allegations in this.
I'll move to accept council's recommendation on all three complaints.
On 19, 20, and 21.
Second.
Moved by Mr. Grease, seconded by Commissioner Franks. Any discussion? Let's vote. All in favor, vote aye.
Aye.
All
We need to read the numbers, though.
Yes.
Okay, read the numbers for 19, 20, and 21.
19 is 2017-037-181, 20, 2017-037-221, and 21, 2017-037-141.
Motion for all three is a consent order for litigation monitoring. All in favor, vote aye.
Aye.
All opposed, vote no. That motion carries unanimously. Number 22, please.
Number 22, 2017-038-561. Complainant alleges respondent is allowing her office in Tennessee to operate without a principal broker and claims the respondent now lives in Georgia. Complainant states that the Tennessee office also has no licensed agents to lease the homes. Complainant provides no evidence or documentation to support these allegations. Respondent confirms that she lives in Georgia, but states that as the principal broker for the Tennessee office, she is involved in all lease signing and rent negotiations on a daily basis with the Tennessee office. Respondent is not aware of any statute or rule that requires respondent to live in Tennessee to be the principal broker for the Tennessee office. Respondent states that she has knowledge of all daily operations concerning the leasing process in the Tennessee office. Respondent's understanding is that the leasing specialists at the Tennessee office do not need to have a license because they are not negotiating rent or showing the properties. Complainant sent a rebuttal stating that the leasing specialists were indeed showing properties, and that is why they are offered gas mileage reimbursement, but complainant is unable to provide proof of these allegations. Counsel looked at respondent's company's website, and each page states at the bottom, quote, "Company is a licensed real estate broker in each state in which it operates," end quote. Counsel recommends dismissal because respondent is not in violation of any statute or rules by acting as the principal broker of the Tennessee location while living in Georgia. Therefore, my recommendation is to dismiss.
Move to dismiss.
Motion by Commissioner Woods, seconded by Commissioner Taylor to dismiss. Discussion?
Where is it that it's talks about the principal broker can live out of state?
It really isn't anything.
It never.
The 50-mile rule
researched.
used to say an affiliate.
Okay, so where's that lady, this person getting this rule then?
She's saying it's not, that there is no rule preventing
Responded
it.
on this said they were not aware of any statute or rule that required her to live in state.
So there is no
which
statute
she's
or rule?
correct. There's no statute or rule.
All right, so can we make a rule? Because this is a problem. This is
that was my whole issue with the
bad
50-mile rule with
yeah,
the
this
affiliates.
Is bad. A principal broker is different than an affiliate. And where in Georgia do they live? They could live in Atlanta. Are they?
Kingsport
are they
had
going
a
to
broker
Kingsport every day?
Kingsport had a broker that lived in Florida.
Yeah.
So
She's also-
therefore, the 50-mile rule for the agent was null.
And she's also acting as the principal broker for the Georgia office.
She has dual licenses?
Yes.
Well, it's true that there's no law that requires her to live in Tennessee. And right now, we're dealing with this complaint. Now, if you want to put on the agenda for next month a discussion of a new rule,
I would like to be put on
We
the
can do
agenda for
that.
next month to talk about the new rule.
but today, our legal counsel has told us there's no law that this person has violated.
And can we hold this one till next month then?
No, 'cause
Well, you
it was
couldn't have a
filed in-
retroactive application of your new rule.
Okay.
I had that. I worked long and hard on this. I went back and forth. I really thought I would find something. Like I thought for sure I would be recommending a civil penalty, but I just could not find
A
anything.
motion by Commissioner Hills to
Dismiss.
dismiss. Is there a second? Seconded by Commissioner Taylor. Further discussion. Now, if we had an instance in which this person had failed to supervise, that could be a violation. Is that correct?
Yes. Yes.
But that's not what's alleged here.
Right. And supposedly there's no agents at the office. They're all leasing specialists, so there's
And
no
so
one.
what's that?
Well,
what's a listing specialist?
She says a leasing specialist is someone who does not, she only tells me what they don't do, does not negotiate rent, does not sign leases, does not show properties. Complainant says they do, but can't tell me how she knows that or why she knows it or give me any evidence or witnesses or.
All right, the motion is to dismiss. All in favor vote aye.
Aye.
All opposed vote no.
No.
That motion carries 7-1 with Commissioner Franks voting no.
Who voted no again?
Commissioner
Marcia
Franks.
Franks. Okay, just check.
From Williamson County. Number 23, please.
2017-038-681, and this is, the respondent is the firm mentioned in the prior complaint that we just discussed.
Move to accept council's recommendation.
Second.
Motion by Commissioner Grease, seconded by Commissioner Taylor to dismiss. Discussion? All in favor vote aye.
Aye.
All opposed vote no. That motion carries unanimously. Thank you, Ms. Smith. I'll turn it back over to Mr. Grease.
Thank you, Mr. McMullen. Sarah, anything else legal-wise?
No, I'm just going to work on some rules, I think.
Don't go too much into that. Caitlin, anything else?
No.
Great. Okay, Fontaine, you have any parting words for?
It's just a pleasure to attend these meetings and also a pleasure to have dismissed early.
Not yet. We're not dismissed yet.
Oh, well, we're on the cusp.
Okay, Gary?
No, I do not, but it's been a good meeting, and good day. Thank you.
Rick?
Congratulations
Wait,
to you
wait.
ladies who have been promoted.
Wait, yeah, let's,
Oh,
Rihanna, do you want to talk about your new job or what a good job you're doing there or anything like that? Oh. Congratulations.
Thank you.
Perfect. Thank you, Rick, for bringing that up. Is that it?
Yes, sir.
You're sure?
I'll end with that. Yes,
Okay,
sir.
Bobby?
Dennis.
Oh,
Status of Dennis.
Yeah.
he's upstairs.
Okay. It just made me think when we were talking, when Robin was talking earlier, I'm like, what's happened to Dennis? Okay.
She's going to we'll text him and see if he'll just pop down.
Okay. I'm just making
Yeah,
sure he was
he,
okay. Okay.
When did he get back, Rihanna? He kind of surprised us. We didn't know he was coming back, and then all of a sudden somebody yelled, "Dennis is in the office," and he's back. So.
Great.
Well, good. No, I don't have anything. We just hope, we're glad Dennis is back. We look forward to Johnny getting back, so.
Marcia?
Did we want to say anything about Christmas lunch?
Not yet.
Okay. Okay.
It's not even Thanksgiving.
Okay.
I'll make something chocolate.
That's a positive.
Got that on the record.
Yeah, that's all right. Did you want to say anything about anything else?
No.
Okay.
Good meeting today.
Diane?
Good meeting. Again, I enjoyed Austin's class. He just did a great job, and I like the idea of getting more information out, going around the state, and I think that's, I appreciate everything that our executive director's doing and trying to look for other avenues out there. I really appreciate it, and
Whispering, aren't they?
Sarah got a promotion?
Sarah got a promotion?
Know about
So, and
What was
Sarah
it?
got a
What wasn't at dinner?
promotion, so I thought we had sort of skipped it all day today.
Sarah.
What?
No, I'm just a supervising attorney now for legal. So.
Well, I broke the news.
Good.
So I was paying
Thank you.
attention
Well
last
deserved.
night, wasn't I?
I was
She
not,
was.
Well
apparently.
deserved.
Yeah. That's great.
Are you still with us?
Yes.
Okay,
Not
that's all that
leaving yet.
matters. That's all that cares.
Not only am I still with you, but I got land surveyors and home inspectors as well. So
That's a personal problem.
yeah,
Okay, then just
no,
stay
it
with
really
us.
is.
So I'm glad I made that
Thank you.
announcement.
That's very good. Yeah. Austin?
Nothing to add. Godspeed to all.
Lily, we're glad you're, or Lillian, you won't tell me which one
Lily.
you prefer. I know,
What's
but
your mama call
She told me Lily.
Mother calls me Lillian.
Lillian. That's her name,
Oh.
Lillian, then.
Okay.
Have you always resented that?
I love
It
it.
is what it is.
but in any case, we're glad you're here. Look forward to working with you. Sherry, thank you. We're thinking about you. We know you've got a health issue to handle, but I think it'll go good. But we're thinking about you. Okay. And finally, has anybody had to call Caitlin for any questions or help on anything? It's pretty cool, huh?
Emailed her.
Well, okay, but I just want to say my final thoughts are that the number of calls I've got generally from people at the Real Estate Commission office has significantly decreased. Significantly decreased.
Significantly.
I will second that.
and I'm most grateful.
No, yours can't.
All right, ladies, thanks. Y'all have a good rest of the month. Happy Thanksgiving. Ha, nobody else said that first. And drive
By the way,
safely.
I'm going to CLE on Friday for Hot Topics in Real Estate, an all-day CLE. So I'll let you guys know at the next meeting if I learn anything wonderful or exciting.
Perfect. All right. Travel safely.
Thanks, ladies.
Did you say anything about that or wrong?
I do have a complaint.